ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬರ್ಬೇಕು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬಂದಿಲ್ವಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇನ್ನೂ ಬಂದಿಲ್ವಾ? 10:27 ಆಯ್ತು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅದ್ರಲ್ಲಿ ನೋಡಿ 3 and 4 ಪ್ರೋಸೆಸ್ ಅಂತ ಹೇಳ್ತೀರಾ, ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಯಾರೋ, ನಾನು ನೆಟ್ ಅಲ್ಲಿ ನೋಡಿದೆ. ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅವ್ರ ಹೆಸರು. ರೆಸ್ಪಾಂಡ್ 3 ಮಾತ್ರ ಇದ್ದಾರೆ, 4 ಇಲ್ಲ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಯಾರೋ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ, ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡಿ ಸರ್.
ಅದೇ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಏನ್ ಹಾಕಿದ್ ಸರ್ ಅದೇ ಇರುತ್ತೆ ಸರ್ ಮೋಸ್ಟ್ಲಿ. ಕೇಳ್ತೀನಿ ಬಿಡಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ಇದೆ, ನೆಟ್ ಅಲ್ಲಿ ಇದೆ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 and 4 ವಕಾಲತ್ ಅಂತಿದೆ, ತಪ್ಪು ಇದೇನೋ ಗೊತ್ತಿಲ್ಲ.
ಬ್ರಾಂಚ್ ಹೇಳ್ತೀನಿ ಸರ್, ಬ್ರಾಂಚ್ ಹೇಳ್ತೀನಿ.
ಕಂಪನಿ ಯಾವುದು? ಯಾವ ಕಂಪನಿ ಅದು?
ಅದು ಇದು ಯಾವುದು? ಚೋಳಮಂಡಲಂ.
ರವಿ ಸಂಪ್ರತಿನ ಇಲ್ಲ ಇವ್ರ ಇರ್ಬೇಕು ನೋಡಿ, HS ಲಿಂಗರಾಜ್.
ಹೌದಾ? Muted. High Court proceeding muted.
The courthouse muted.
23. Melod.
23. No, Nare, 2012. Huh? No, Nare, the impleading Tana. You are get 26 ಅಲ್ಲಿ ಮಾಡ್ರಿ ಏನಾಗಬೇಕಿತ್ತು ಮೋಸ್ಟ್ಲಿ ರೀಚ್ ಆಗಲ್ಲ. ಬಂದಿದಾರಲ್ಲ ಇನ್ನೇನು ನೋಡ್ರಿ ಅಡ್ಮಿಷನ್ ತಾನೆ ಯಾರು ಇಲ್ಲ ಇದೇನೋ ಅದು ಆರ್ಡರ್ ರೀಕಾಲ್ ಮಾಡಿದ್ ನಾನು. No, I recalled an order by virtue of the prayer in the other petition. Now this will be formally disposed of. That is all. ಮುಗಿಸ್ತೇನೆ ತಗೊಂಡ ಹೇಗಿದೆ ಮೆಮೊ ಇಲ್ಲಿ ಇಲ್ಲ ರೆಪ್ರೆಸೆಂಟ್ ಹೇಳಿಲ್ವಾ ನೀವು ಅದರಲ್ಲಿ ಬರ್ ಅವ್ರಿಗೋಸ್ಕರ ನಾನು ಇದು ಮಾಡ್ಲಾ it is made clear that the representation shall be made with reference to yes number 39 measuring 4 acres 31 meters situate at Kolangi H Mandipatna Hobli Arkalgud Taluk Assam district. रिटायरमेंट यार साथ में हो रहा है memo for retirement filed by CDS Nagaraj is accepted. Anybody else appearing on your behalf? Unit idea. Memo retirement is filed stating that it's not being instructed, and an RPA letter also has been issued intimating the party that he would retire. The post acknowledgement is also produced. In view of the above, Sri SDN Prasad is permitted to retire for R2. First, office to print the name of the second respondent. Where is he? Who's R1? Who's R1? Most failed city for dispensation to R1. The risk of government notice to R1 is dispensed. The delay of 276 days in filing the appeal is condoned. The appellant shall however not be entitled for the interest for this period of 276 days. As requested, notice to R1 and R2 dispensed at the risk of the appellant. ಎಷ್ಟಾಗಿದೆ? ಡೆಪಾಸಿಟ್ ಆಗಿದೆ. I have been permitted to the registry is directed to return the order sheet to enable the deposit of the award amount as per the interim order. Registry is also directed to resecure the order sheet thereafter. First along with them. ಆಗಿದೆಯಂತ
My lord, I am for the appellant, my lord.
DB matter ಅಂತ.
I am for the appellant.
Yes.
This matter may be posted to before the division bench, my lord. Both are connected with the division bench matters. Serial number 6 and 6.1.
Posted before the division bench. ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳ್ತೀನಿ? 7. Award amount ಎಷ್ಟು? 50%. Deposit, you deposit 50% here. There should be an interim stay of the my standard is 50%. There's no change. Shall be an interim stay of the award subject to the appellant. You don't have to pay. They will not arrest you and put you behind bars. They can't recover the money from you. So why are you getting? If you want to argue the matter on merits, take an order right now. I will not change that interim order. What do you want? Do you want to argue, or I will not change the interim order? You want to argue the main matter? Next week. It is ready. I'm ready to take it up today itself. You tell me when you want. We can't go according to what the client says. If you're ready to argue today, tomorrow, take a date and argue. You take the date. You have to argue, not me.
Lord, in this case, R3 is a Cholamandalam, my lord. And these net shows, my lord, somebody else filed the wakalat. Whether it's true or not, I don't know. Whether it is available. R3, ಯಾರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ, ಅದ್ರ ವಕಾಲತ್ ಫೈಲ್ಡ್ ಅಂತಿದೆ 3 and 4 ಗೆ. ಆದ್ರೆ ಹೌದಲ್ಲ ಗೊತ್ತಾಗ್ತಿಲ್ಲ, ತಪ್ಪೇಂಟ್ರಿ. ಅದೇ ಲಾಯರ್ ಈಗ ಪ್ರದೀಪ್ ಅಥವಾ ಲಿಂಗರಾಜ್ ಅವ್ರಿಗೆ ಕೊಡ್ಬೋದು. ಅವ್ರಿಗೆ dispensation is also there and the record is to be. Notice to R1 is dispensed. one submission, madam. May I make? Well, it is a very old matter. I filed an IA for early hearing also. Records is not.
20 matter, old matter ಹೆಂಗೆ ಶಾಸ್ತ್ರಿ?
ಅಲ್ಲ 2015 accident is ₹1 ಸಿಕ್ಕಿಲ್ಲ ಅವರಿಗೆ. There is a pressure.
Appeal 2009-10 ಮುಗಿಸ್ಕೊಂಡು
ಹೌದು ಅಲ್ಲ ನಾನು ಅದಲ್ಲ ಹೇಳೋದಿಲ್ಲ. It's the exceptional case wherein I am under trouble. That is why date may be fixed, my lord, after forthwith ಅಂತ ಮಾಡಿದ್ some office. One short
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. Next week. Please ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ? When was the order passed for dispensation? The notice already dispensed with it at the risk of the appellant. So why are you worried? Don't worry about it. An order is passed on who's respond number 1? And respondent 2 and 3 are the children. Respond 5 and 6 are the parents. Huh? What the award amount is? ಈಗ ಡಿವಿಷನ್ ಬೆಂಚ್ ಬರಲ್ವಾ? ವಯಸ್ಸು ಎಷ್ಟು ಅವ್ರಿಗೆ? 22 ಲಕ್ಷದಲ್ಲಿ 10 ಲಕ್ಷ 50% ಡಿಪಾಸಿಟ್ ಇತ್ತು. 22,91,000 ಅವಾರ್ಡ್ ಅಮೌಂಟ್ ಅದ್ರಲ್ಲಿ ಅರ್ಧ ಡಿಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು. ಅರ್ಧ ಆಗ್ಲೇ 10 ಲಕ್ಷ ತಗೊಂಡಿದ್ದಾರೆ. ಅಮೌಂಟ್ ಇರೋದೇ ಡಿಪಾಸಿಟ್ 1.5 ಲಕ್ಷ. 1,91,000 ಇದೆ. ಅದನ್ನಷ್ಟೇ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳಕ್ಕಾಗುತ್ತೆ. Amount in deposit now is only 11,91,000, about 11,45,000. Alva, 10 lakhs they've already withdrawn. Alla. ನಾನು ಹೇಳಿದ್ದು ನಿಮ್ಗೆ ಗೊತ್ತಾಯ್ತಾ? Amount in deposit is only 11,45,000. So the 11 lakhs still right, alva? 43 lakhs. How much is the tribunal granted in the tribunal? Your 5 and 6 k. 5 and 6. 2 lakhs, 4 lakhs. By an order dated 20th of April 2022, respondents 1 to 3, who are the wife and children, were permitted to withdraw a sum of rupees 10 lakhs. An application is now made by the parents of the deceased, seeking for withdrawal of certain sums in their favor. In my view, it would be appropriate to permit respondent number 5 to withdraw sum of rupees 2 lakhs and the respondent number 6 to withdraw a sum of rupees 4 lakhs from the amount deposited by the insurance company pursuant to the interim order. Record. Post immediately after receipt of bank court records, along with MFA 333/2022 before the division.
Millers, I am for the appellate, Miller. This is claimant's appeal for enhancement of the award amount.
Then notice insurance company held the Lakshmana. Take notice.
Number 26, created some.
Argument. Ravi Shankar.
My lord,
Yes. You wanted to find some response.
please, my lord, your lordship may grant, my lord, the 4-5 days time, my lord. We will file because there is one file in my lord. Our instructions are that, my lord, one file is sent to AG's office and it is available there. That is not produced before the court. That may also be looked into, my lord. I kindly grant, my lord, the 1 week time, my lord.
List next Wednesday.
I also seek for time. Sorry, my lord, I came in late. Week's time.
Suman ಅವರಲ್ವಾ? Asor. 2:30 ಧಾರವಾಡ ಲಿಸ್ಟ್ ಒಂದಿದೆ ನಾನು ನೋಡ್ತೀನಿ ಯಾವಾಗ ಈಗ ಎಲ್ಲ ನೋಟಿಸ್ ಆರ್ಡರ್ ಯಾವ್ದ್ರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 16 ನೀವೇ ಯಾರಿಗೆ ನೀವು ಎಷ್ಟು ಅಮೌಂಟ್ on what ground? What ground we filed the appeal? There should be an interim stay of the award subject to the appellant depositing the entire award amount inclusive of interest before this court within a period of 8 weeks. Such deposit, office to invoice the same fixed deposit any nationalized bank.
Time is
Number 22, madam. Stated the appeal is filed in time and an application for conversion of delay was filed by Inland Returns. D of the above, IA 1 for 2022 is dismissed as not pressed. Admit, call for records. 24, same order. 24. Yes, sir. Parents are the claimants. Bachelor. ಏನಕ್ಕೆ? in the goods order. Carrying capacity ಎಷ್ಟಿತ್ತು? Carrying capacity ಎಷ್ಟು? Breach of policy conditions. Correct, but if any accident occurs, but your condition is that he could not have been carried there. So therefore, it is a breach of the permit conditions. Correct, it is a violation of the conditions. Premium ತಗೊಂಡ್ರೆ ನಿಮ್ಮ ಮೇಲೆ ಬರುತ್ತೆ ಕವರೇಜ್. ಪೇ ಅಂಡ್ ರಿಕವರಿ ಏನು? ಕರೆಕ್ಟ್ ಹೇಳಿ ಯಾವ ಜಜ್ಮೆಂಟ್ ಅಪ್ಲೈ ಮಾಡ್ಲಿ ಅಂತ. ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಬೇಡವಾ? ಪ್ರಿನ್ಸಿಪಲ್ ಅದೇ ತಾನೆ. ಆ ಟ್ರ್ಯಾಕ್ ಏನಿತ್ತು ಎಕ್ಸೆಪ್ಟ್ ಪರ್ಸನ್ ಎನ್ಬಿಡಿ ಇಲ್ಲ, ಈ ಡಿಸಿಷನ್ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡಬಾರ್ದು ಅಂತ ಮಾಡಿದಾರ. ಫುಲ್ ಬೆಂಚ್ ಇದ್ರೆ ನಾನೇನ್ ಮಾಡಿ? ಸರ್ 2010 ಇವತ್ತು ನೋಡೋಣ, ಒಂದೇ ಕ್ವಶನ್ ಇದ್ರೆ ಯಾಕೆ ಅದಕ್ಕೆ ಮುಂದಕ್ಕೆ ಹೋಗೋದು? ಸರ್ 2 ಅಪೀಲ್ ಯಾಕೆ? ಅಂದ್ರೆ ಆಟೋ ರಿಕ್ಷಾ ಡ್ರೈವರ್ ಬಿಟ್ಟು ಇನ್ನಿಬ್ರು ಇದ್ರ? ಪ್ರದೀಪ್ ಅದ್ ನೋಡಿದ್ರ ಕ್ಲಾಸಿಫಿಕೇಶನ್? ಅದ್ ಬರೀ MBC ಮಾತ್ರ. ಇನ್ನೇನಿದ್ರೆ ಎಲ್ಲರಿಗೂ ತೋರ್ಸ್ಬಿಟ್ಟು ನಾವ್ ಒಂದು ಹೇಳಿದ್ರೆ $29. Expert ನಲ್ತೆ ಪ್ರದೀಪ್ ಲಿಂಗರಾಜ್ ನೋಡ್ತೀರಾ? ಪ್ರದೀಪ್ ಲಿಂಗರಾಜ್ announcement ga kodu paper kodu. ಏನ್ injury ಏನು? The mandible fracture of left maxilla and fracture of right zygomatic nerve tendon. ಎಷ್ಟು ದಿನ ಇದ್ರ ಹಾಸ್ಪಿಟಲ್? Why was he shifted to Nimmans? Nimmans ಅಲ್ಲಿ 3 ತಿಂಗಳಿದ್ರ? ಇಲ್ಲ para 11. No. Para 11 ಬನ್ನಿ. He was shifted to Kolar and from there he was shifted to Jalappa and also shifted to Nimmans. Where he has taken treatment as inpatient for 3 months. Very simple injury ಆಗುತ್ತೆ 3 ತಿಂಗಳಲ್ಲಿ. Now 3 ತಿಂಗಳು. Now will they keep him in Nimmans for 3 months for a simple injury? ಆಮೇಲೆ 3 ತಿಂಗಳು. ಮೂರು ತಿಂಗಳಿದ್ರೇನ್ರಿ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ? 3 ತಿಂಗಳಿದ್ರೆ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿ ಎಷ್ಟು ದಿನ ಆಯ್ತು? ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಾ? ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಂದ ಗೊತ್ತಾಗಲ್ಲ. ಇದೇನೇ ಎಕ್ಸಿಬಿಟ್ P4 ಕೊಡಿ. ಇಲ್ಲೇ 1 ತಿಂಗಳು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. 12/2/2008 to 18/3/2008. discharge summary ಇದೆಯಲ್ಲ, deformity of left arm, patient was admitted on 11/2/2008 with alleged history of RTA. Patient was unconscious at admission. General condition shown improvement on 3rd of March 15. Improved July 15 on 13/2/2008 and was on spontaneous mode of ventilation and was responding to painful stimuli. Tracheostomy tube was put and Rayleigh tube feeding given. Soft diet started on 5/3/2008. On 23/2008, maxillary surgery surgeon reference. He was unconscious and ventilator for discharge summary ಇದೆಯಲ್ಲ. What is the evidence that he has given regarding his ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ ಏನ್ ತೊಂದರೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿದಾರೆ. There are two. ಕಾಯಿಲೆ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲವಲ್ರಿ ಇವರು.
ಇಯರ್ಫೋನ್ ಇದೆ ಇಯರ್ಫೋನ್ ಇದೆಯಲ್ಲ ಇಯರ್ಫೋನು
What is the evidence to show that there is any permanent disability? ಆಯ್ತು ಅದಾಯ್ತು, ಅದ್ ಬಿಟ್ಟಾದ್ಮೇಲೆ ಎಫೆಕ್ಟ್ ಏನಾಗಿದೆ? ಕೈಕಾಲ್ಗೆಲ್ಲ ಸರಿ ಇದೆಯಾ? ನೀವ್ ಹೇಳೋದಲ್ಲ, ಅವ್ನು ನಿಮ್ ಪಾರ್ಟಿ ಹೇಳ್ಬೇಕಿತ್ತು ಕೋರ್ಟಲ್ಲಿ. What is the lasting effect of this? ಅವ್ರಿಗೆ ಏನಾಗಿದೆ ಅಂತ ಎಲ್ಲಿದೆ ಎವಿಡೆನ್ಸ್? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಇದು? ಪೇರೆಂಟ್ಸ್ ಸಫರಿಂಗ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 3 months ಅಷ್ಟೇ ಆಗುತ್ತಾ? ಅವನ ವೆಂಟಿಲೇಟರ್ the discussion for 3 months if he's in an hospital, is that is all the bill? ಇದ್ರ ಪ್ರಕಾರನೇ 1 ತಿಂಗಳು 1 month 3 days 6 ಇಲ್ಲಿರೋದು 12/2/2008 to 18/3/2008. So 1 month 6 days ಇದ್ರೆ ಬರೀ 22,000 ಆಗುತ್ತೆ. But the fact remains he was in the hospital for a month. ಇದೇನ ಬರೀ ಫಾರ್ಮಸಿ ಬಿಲ್ಸ್ ಇದೆ ಅಷ್ಟೇ. ಹಾಸ್ಪಿಟಲ್ ಚಾರ್ಜಸ್ ಆಮೇಲೆ ನಿಮ್ಯಾನ್ಸಿ ಬಂದ್ಬಿಟ್ಟು ವಾಪಸ್ ಬಂದು ಅದಕ್ಕೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಎಷ್ಟು ಹೇಳಿದ್ರೆ ಖರ್ಚಾಗಿದೆ ಅಂತ ಹಾಸ್ಪಿಟಲ್ ಅದು ಬರೀ ಫಾರ್ಮಸಿ ಇದೆ. But I'll take judicial notice of the fact that he was in the hospital for 1 month. Is proof of that? Now, will the hospital treated? Correct. Suppose they don't have the medical bills. He was on a ventilator. He was in hospital for more than a month on a ventilator. You tell me what is reasonable expenditure even in Jalapa hospital. Whether they produce or not produce. Whether they produce or not produce, Jalapa hospital not treat them free. ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಹೇಳಿ, ಅದೆಲ್ಲ ಕೊಟ್ಟೆ ಕೊಡ್ತೀನಿ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್. There's no such rule that only the bills are produced to given. I can take cognizance of he's gone from Kolar to Immense back to other medical expenses for the ambulance in clear out of Tara. ಈ ಆರ್ಟ್ಸ್ ನಿಮ್ಗೆ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ನೀವು ಯಾವ್ದು ಪ್ರೂವ್ ಮಾಡಲ್ಲ. Pain and suffering, I'll make 2 lakhs. Medical expenses 22,000. 2,000. 1,50,000. Medical expenses, I'll add another 50,000. Over and about 22,000. Conveyance charges 25,000. Attendant charges same 25,000. Loss of income ಏನ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀವನ, ಯಾವ ವರ್ಷದ ಆಕ್ಸಿಡೆಂಟ್ ಎಷ್ಟಿತ್ತು ಅವಾಗ? 3,000. ಬರೀ 1 ತಿಂಗಳು ಕೊಟ್ಟಿದಾರ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ವೆಂಟಿಲೇಟರ್ 1 ತಿಂಗಳಿಂದಲ್ಲ. Extra nourishment and food 25,000. The 6 months are 3,700 into 6. 22,200. Anyone? This is an appeal by the claimant being dissatisfied with the sum of rupees 73,167 awarded by the tribunal. The fact that an accident occurred and that the claimant suffered injuries is not in dispute. It is also not in dispute that the offending vehicle was insured. The tribunal, on consideration of the evidence adduced before it, has proceeded to award the following sums. Page 50. The tribunal, in its award, has come to the conclusion that the claimant had suffered only 1 simple injury and 3 grievous injuries, and was hence entailed only into a sum of rupees 35,000 towards pain and suffering. The claimant had produced the discharge summary issued by R.L. Jalappa, Hospital and Research Center. The said discharge summary indicates that the claimant had suffered right side orbital bone, which the discharge summary also has recorded The course of treatment administered to the claimant as follows. As could be seen from the said discharge summary, the claimant was unconscious and at the time of admission, and he was put on ventilator, and he was also subjected to a tracheostomy, and he was fed through a Riles tube. The discharge summary clearly states that he was an inpatient for more than 1 year, for more than 1 month, 6 days in RL Jalapa Hospital. The course of treatment given to the claimant indicates that he has suffered a serious head injury and was put on ventilation. It is also to be noticed here that the claimant was initially referred to Nimmans, and from thereafter he was referred back and admitted to RL Jalapa Hospital. Again, thereafter, Nimmans admit ಆಗಿದ್ದಾನೆ. There's an outpatient slip for this. No, there is an outpatient slip of Nimmans here. It is also to be, the claimant has also produced exhibit P8, which also indicates that he has undergone treatment at Nimmans from 14th of April 2008 to 3rd of June 2008. The said medical record indicates that the claimant had gone into depression, and it was a post-traumatic event. The record also indicates that he was treated as an outpatient for more than 2 months, and he was diagnosed with having organic brain syndrome, and he reported improvement, though he complained of mild irritability. These facts, these documents clearly and conclusively prove that the claimant had suffered a serious head injury which necessitated him being put on a ventilator and also being treated for the organic brain syndrome. No doubt, there is no record to show that the claimant has suffered any physical deformity, but judicial notice can be taken of the fact that a person who has suffered an head injury and has undergone hospitalization for more than 1 month would have suffered immeasurably, and there would also be lasting effects on that person. In that view of the matter, in my view, it would be appropriate to enhance the sum of rupees 35,000 awarded towards pain and suffering, rupees 1,50,000. The tribunal has awarded a sum of rupees 22,067 on the basis of the bills produced by the claimant. The perusal of the bills produced by the claimant indicate that there are all bills relating to purchase of medicines. No bill is however produced to show these sums being paid to the hospitals. It cannot be in dispute that R.L. Jalapa Hospital is a private hospital, and it is nobody's case that the claimant was treated free of cost. In view of the fact that the claimant was hospitalized for more than 1 month and was kept on ventilator, in my view, it would be appropriate to award some rupees 50,000 towards global expenses, towards medical expenses. The claimant has been awarded a sum of rupees 5,000 and 3,700 towards conveyance charges and attendant charges. Since it cannot be in dispute that the claimant was hospitalized for more than 1 month, it would be inevitable that these caretakers would have spent considerable amount of time and money during his stay in the hospital. Therefore, of the view that he said some request enhanced to rupees 25,000 towards conveyance charges and rupees 25,000 towards attendant charges. The tribunal has awarded a sum of rupees 3,700 towards loss of income by taking the income of the claimant at rupees 3,700. As stated above, the medical records indicate that he underwent treatment for more than 6 months. And having regard to this fact, the claimant would be entitled to loss of income for a period of 6 months, which would be rupees 22,200. The tribunal has lastly awarded a sum of rupees 3,700 towards nourishment and food charges. In my view, in regard to the length of the stay of the claimant, the same would have been enhanced to rupees 25,000. Consequently, the claimant will be entitled to the following sums: 6% interest. ಲಯಬಿಲಿಟಿ ಏನು ಕ್ವೆಶ್ಚನ್ ಇಲ್ಲ ಅಲ್ವಾ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? What is the injury? ಬರೀ ಲ್ಯಾಸರೇಷನ್ಸ್ ಅಷ್ಟೇನಾ? ಫ್ರಾಕ್ಚರ್ ಇದೆಯಾ? ಎಲ್ಲಿ ಹೇಳಿದಾರೆ? Where is the set about disability? ಅಂಗನವಾಡಿ ಟೀಚರ್. What is the income that is taken? About loss of earning capacity illa alva. She's getting the same pay. Okay, but no, that pain and suffering and loss of immunity is a makeup. But loss of earning capacity can't be attributed. That will be continued. Let's go to the pain and suffering. Straight up ಮಾಡಿಲ್ವಾ? ಎಲ್ಲಿ ಮಾಡಿದಾರೆ? ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 26,000, 27,000, 5,000 ಕನ್ವೇಯನ್ಸ್, 25,000 ಪೇನ್ ಅಂಡ್ ಇದೆ. ನಿನ್ನ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಏನಾದ್ರು ಎಷ್ಟು? ಏನೇನ್ ಜಾಸ್ತಿ ಮಾಡ್ಬೋದು? But she has suffered loss of muscle to her arm. Page number para 33 one. Para 33. PW2 doctor has also stated with regard to restriction in the movement of the right shoulder, right forearm, and also stated the patient is unable to do overhead activities carrying heavy object. This goes to show that other male garden. She also stated that she has lost strength in the right hand and also stated that with loss of muscle, the appearance of the physique of the patient has been disfigured. Huh? Where was she treated? Manipal Hospital. Discharge summary ಇದೆ. Disability certificate ನೋಡಿ. This is by the assistant professor of KMC Hospital, Manipal. Loss of earning capacity ಹೇಳ್ತಿಲ್ಲ ನಾನು. Correct. ಅದಕ್ಕೆ loss of amenities ಗೆ there is 40% loss of movement at ಅವ್ರಿಗೆ ಎಲ್ಲಿಂದ ಅವ್ರು ಬಂದ್ರೆ ಸಾಕು, ಯಾವ ಹೆಡ್ಡಲ್ಲಿ ಕೊಟ್ಟರು ಅವ್ರಿಗೆ ನಾವೇ ಕಾಸು ಕೊಡಬೇಕಷ್ಟೇ. ಅವ್ರಿಗೆ ನಾವ್ ಹೆಡ್ ಹಾಕದ್ ನಾವ್ ತಾನೆ, ಯಾವ್ದಕ್ಕೇನು ಅಲ್ಲ. Look at this. There is the 40% loss of movement of right shoulder. There is 45% loss of movement of right forearm. There is 40% loss of power of right shoulder and elbow muscles. There is 90% loss of grip strength and 30% loss of pin strength. What do you think is reasonable as loss of amenities for a lady? To have undergone virtually her right side is gone. She may get a job, she may get the same salary. But this kind of a deformity she'll have to live throughout her life. But this is the disability of the doctor of KMC. 40% loss of movement. This is not something which should come back. Then 45% movement of right forearm. 40% loss of power of right shoulder and elbow muscles. 90% loss of grip strength. So she can't really hold anything. The claimant is in the peak, being dissatisfied with the compensation of rupees 97,000, 92,500 awarded to her as compensation for injuries suffered by her in an accident which is not in dispute. And the liability of the insurer to satisfy the compensation is also not in dispute. The claimant is an Anganwadi worker who suffered an accident and was treated at Manipal Hospital. From 5/1/2009 to 31/2009. The claimant was admitted with the following injuries. A disability certificate was produced as exhibit 11 by the Assistant Professor, Department of Orthopedics, Kasturba Medical College, Hospital Manipal, in which the following findings are recorded. It is thus clear that the claimant has lost the complete use of her right arm and she has suffered 29% permanent disability of her right upper limb. It is no doubt true that the claimant has continued to work as an Anganwadi teacher. Therefore, there will be no loss of future income by virtue of the accident. However, having regard to the injuries suffered by the claimant, the sum of rupees 25,000 awarded to the tribunal towards pain and suffering would have to be increased to rupees 1 lakh. The sums awarded by the tribunal towards medical expenses at rupees 27,000 being based on documentary evidence is affirmed. The tribunal has awarded some rupees 5,000 towards conveyance, nourishment, and other incidental expenses. In my view, the said sum request to be enhanced to rupees 15,000. The tribunal has awarded a sum of rupees 10,000 towards future medical expenses. Though a certificate by Exhibit P21 has been issued by the KMC Manipal, stating that you would require a sum of rupees 65,000 for future medical expenses. In view of Exhibit P21, the certificate issued by KMC Manipal, will be appropriate to award sum of rupees 65,000 towards future medical expenses. The tribunal has awarded some rupees 15,000 towards loss of immunities and future unhappiness. As narrated above, the claimant has virtually lost the use of her right forearm. And essentially, she cannot grip any object since she has lost 90% grip strength and 30% of pinch strength. Having regard to the permanent nature of the disability suffered by the claimant, I deem it appropriate to award a sum of rupees 1,50,000 towards loss of immunities. Consequently, the claimant will entitled to the following sums.
My lord, as per the appellant, my lord. Case of injuries, my lord.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
My lord, case of injuries, total amount awarded is 85,000 rupees.
ಏನ್ injuries ಏನು?
Injuries are the page number 6 of judgment or internal page number 13 total overall. Para 12. Heel avulsion with loss of heel and plantar skin 13.8 centimeters dimension. Calcaneum exposed. Abrasion over anterior medial aspects of left knee 5.4 centimeter. Abrasion over left shoulder anterior and superior aspect 8.5 centimeter. Multiple abrasion over dorsum of left hand 6 in numbers, each about 1.1 centimeters. Tenderness present over left inguinal region 5.5 centimeters. In this heel, skin peeled over the heel and the plantar skin, heel and knee.
Evidence ಏನು?
PW2, the doctor has led the evidence and he has conducted 2 surgeries, which are referred in page number 15, my lord. I will read out, my lord. He, para 3.
31% left over. What was it?
Yes. He was a postman, my lord.
ಸಂಬಳ ಏನು ಕಮ್ಮಿ ಆಗಿರಲ್ಲ ಅಲ್ವಾ?
No, loss of earnings has been not, we are not claiming the loss of earnings. Moreover, 8,000 rupees has been awarded. 8,500 has been awarded in respect of laid down period. 33 days payment to ಕೊಟ್ಟಿದ್ದಾರೆ post office ಅಲ್ಲಿ. Moreover, he was 2 months as an inpatient in Lady and Curzon Boring Hospital. So from 25/8/2010 to 28/10/2010. Medical expenses ಕಡಿಮೆ ಇದೆ, ಅದೇನಿದೆ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ. Bill has been awarded. On the head of disability, loss of pain and sufferings, amenities, so it has to be awarded. Enhanced bill.
The 29% disability is hospitalized for 2 months. Pain and suffering is ಮಾಡಿ. 2 ತಿಂಗಳು ಹಾಸ್ಪಿಟಲ್ ಇರಲಿ ಅಟ್ಲೀಸ್ಟ್. He has suffered heel avulsion and heel avulsion ಅಂದ್ರೆ serious. 1 lakh ಮಾಡ್ತೀವಿ. Loss of immunities ಏನ್ ಮಾಡೋಣ? 29% ಅಂತಂದ್ರೆ loss of immunities ಎಷ್ಟು ಮಾಡ್ಲಿ? ಅದು 1 ಲಕ್ಷ ಮಾಡ್ಬಿಡ್ಲಾ? 29% disability right lower limb ಅಂತಾರ. Right ಆದ್ರೂ 25,000. Medical charges same. Loss of earnings same. Permanent disability ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
20,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
Make loss of immunities 50,000 and permanent disability 50,000. 2 ತಿಂಗಳು ಹಾಸ್ಪಿಟಲ್ ಇರೋರು ನೀವು.
ಕನ್ವೆನ್ಸ್ ಏನು ಕೊಟ್ಟೇ ಇಲ್ಲ ಸ್ವಾಮಿ. He was he is from native Bandu Gudibande Taluk Chikbalapur district. He was admitted in Boring Hospital, Bangalore for almost 2 months.
Being dissatisfied with the compensation which is 80,512. The payment. The tribunal on consideration of the evidence has awarded the following substance. The tribunal has recorded that the claimant suffered the following injuries. It has also recorded that the claimant underwent 2 surgeries, the following 2 surgeries. The tribunal has also noticed that the doctor was examined has assessed the physical disability at 31.4% of the left lower limb. And the claimant would have to undergo repeated dressings and also plastic surgery with a free flap for his heel. Taking note of these injuries, the tribunal has however awarded only a sum of rupees 20,000. The tribunal has also noticed that the claimant was an inpatient in Boring Hospital from 28/8/2010 to 25/10/2010. That is for nearly 2 months. In my view, having regard to the fact that the claimant has suffered an heel avulsion with loss of heel and has undergone 2 surgeries, it would be appropriate to award the sum of rupees 1 lakh towards pain and suffering as against sum of rupees 20,000. The tribunal has awarded rupees 10,000 towards loss of future amenities. Having regard to the fact that the claimant has suffered physical disability of 31.4% to his left lower limb, it will be appropriate to enhance the said sum to rupees 50,000. The sum of rupees 17,000 awarded towards medical and incidental charges and rupees 8,512 towards loss of earning being based on documented evidence is affirmed. The tribunal is awarded sum of rupees 20,000 as permanent disability. In my view, I with regard to the fact that the claimant has lost his heel, had lost his heel and plantar skin, it would be appropriate to award enhance the said sum rupees 50,000. The tribunal has not awarded any sum towards conveyance, nourishment, and attendant charges. If the claimant was inpatient for more than 2 months, it would be appropriate to award a sum of rupees 25,000 towards conveyance, nourishment, and attendant charges. Consequently, the claimant will be entitled to the following sums. Ilbadwa. Again, KSN. What is the case about? Master Faizan, 7-year-old. ಎಷ್ಟು ಬೇಕು ನಿಮ್ಗೆ 40,000 ರೂಪಾಯಿ ಎಷ್ಟು ಬೇಕು ನೀವ್ ಹೇಳ್ರಿ ಅವ್ರಿಗೇನ್ ಬೇಕು ಇದಕ್ಕೆ 40,000 ರೂಪಾಯಿ ಕೇಸ್ಗೆ ಏನಾಗಿದೆ ಯಾರ ನೋಡಿ ಎಷ್ಟು ದಿನ ಇದ್ರು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ವಿಕ್ರಮ್ ಹಾಸ್ಪಿಟಲ್ ಏನ್ 50% ಯಾಕೆ ಎರಡು ಕಾರ್ಗೂ ಇನ್ಶೂರೆನ್ಸ್ ಯುನೈಟೆಡ್ ಏನಾ ಇನ್ನೊಂದು He was in the hospital for 3 days. He was in the ICU for 2 days because of a suspected head injury. So 40,000 ಖಂಡಿತ ಕಮ್ಮಿ ಆಗುತ್ತೆ. ಎಷ್ಟು ಮಾಡಲಿ ICU ವಿಕ್ರಮ್ ಹಾಸ್ಪಿಟಲ್ ICU ಅಂದ್ರೆ ಮೂರು ದಿನ ಇದ್ರೆ ಎಷ್ಟಾಗತ್ತೆ ಹೇಳಿ ನೀವು ವಿಕ್ರಮ್ ಹಾಸ್ಪಿಟಲ್ ಇಸ್ ನಾಟ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಚೀಪ್ ಇವನ್ ದೆನ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ಚೀಪ್ ತಾನೆ for 3 days ICU ಬಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತು ಜಾಸ್ತಿ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಸೀನಿಯರ್ ತೊಂದರೆ ಆಗಲ್ಲ 14,980 ರೂಪಾಯಿ ಇದೆ ಬಿಲ್ ಹುಡುಗನ ಹೆಸರು ಫೈಜಾನ್ ಅಲ್ವಾ one cash receipt bill for 14,980 15,000 ರೂಪಾಯಿ ತಗೊಂಡಿದ್ದಾರೆ ಕ್ಯಾಶ್ ಅಂತ ಇದೆ ರಿಸಿಟ್ ಇದೆ $20,000 ಇದೆ ಬಿಲ್ 19,980. I'll grant 25,000 towards medical expenses and 80,000 towards that. ಏನಿದೆಯೋ ಅದನ್ನೇ liability ಯಾರ ಮೇಲೆ? Why 50%? Only 50% against you? The respondent was only one vehicle, then. The respondents body owner of driver vehicle K09 MF. Connected matter ಏನಾಯ್ತು? ಡಿವಿಷನ್ ಏನಾಯ್ತು? What is the reason for 50%? The charge sheet was laid against Nimele alva. I'm not inclined. ಅಲ್ಲ ಅವಾಗ ಎನ್ಹಾನ್ಸ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ ಬರುತ್ತೆ. ಅವಾಗ ನಾನು ಡಬಲ್ ಟ್ರಿಪಲ್ ಮಾಡಿದ್ರು 50% ಅಷ್ಟೇ ಬರುತ್ತೆ. I will satisfy the finding regarding that negligence and make you completely liable. ಆಗುತ್ತೆ. ಅದು ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನಿಮ್ಗೆ ಇದು ಉಳಿದಿದೆ. ಬೇಡ ಬೇಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ. The accident occurred at an intersection, but he had clear vision. Correct. The claimant being dissatisfied, the compensation of rupees 40,000 is an appeal. The claimant is a 7-year-old who suffered suspected head injury, and as per the discharge summary issued by Vikram Hospital, which is produced as the P14, he was admitted on the 24th of August and discharged on 27th of August. The discharge summary indicates that the claimant was kept in the ICU on 24th of August 2008, and the CT scan indicated that he had mild cerebral edema, and he was treated conservatively with analgesics, antibiotics, anti-edema measures, and other supportive medicine. The summary also records that debridement and suturing of the forehead laceration was also done. and he was discharged on the 28th. In my view, having regard to the fact that the claimant was in the ICU and was admittedly an inpatient for 3 days, the sum of rupees, yeah, paragraph 40,000, the sum of rupees global compensation is 40,000 awarded deserves to be enhanced to rupees 80,000. The claimant has also produced a bill of Vikramascopy as exhibit. P1, which indicates that the total sum of rupees 19,980 was paid having regard to exhibit P1. It will be appropriate to award a sum of rupees 30,000 rupees towards medical expenses. The tribunal has come to the conclusion that the car driven by the car in which the claimant was traveling, the driver of the car in which the claimant was riding, was also responsible for the accident, and it has accordingly apportioned the negligence in the ratio of 50-50. Perusal of the sketch, which is produced as exhibit P10, indicates that the accident occurred at an intersection. The sketch also indicates that the offending vehicle had to necessarily have a clear vision of the entire road, since the road is straight and the accident has also occurred virtually after the petitioner, the car in which the claimant was traveling, had crossed the intersection. Having regard to this sketch, in my view, the finding of the tribunal that the driver of the car in which the claimant was traveling was also equally responsible cannot be sustained. And it will have to be held that it is the driver of the offending vehicle alone was responsible for the said accident. Consequently, the appeal is allowed, but some more rupees 1,10,000 is awarded as compensation, and this compensation will be payable entirely by the third respondent. 6%. ಕಮ್ಮಿ ಕೊಟ್ಟಿದಾರಾ? ಕಮ್ಮಿ ಕೊಟ್ಟಿದಾರಾ? ಆ ಪೇಮೆಂಟ್ ಯಾಕಂದ್ರೆ ಇವಾಗ ಹೆಗ್ಡೆ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಪ್ರಕಾರ 1,50,000 ರೂಪಾಯಿ ವ್ಯಾಲ್ಯೂ ಜಾಸ್ತಿ ಆಯ್ತು ಅಂತ ಅಂದ್ರೆ ಎಷ್ಟಾಗತ್ತೆ ಇದು? This is Anant Hegde has rendered a judgment saying that this amount was determined when. So having regard to the value of money, erosion of value of the money now, what is the money that should be granted? Correct. The amount is also, let us say, determined, but that can't be static forever. 1 lakh ಸರಿ ಎಷ್ಟು ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಆ ಪರ್ಸೆಂಟೇಜ್ ನಾನು ಏನು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಕ್ ಹೋಗಲ್ಲ. ಈ 1.5 ಲಕ್ಷ ಬದಲು ಅವಾಗಿನ 1.5 ಲಕ್ಷ 2014 ಅಲ್ಲಿ, ಈಗ 2022 ಅಲ್ಲಿ ಎಷ್ಟಾಗುತ್ತೆ ಆಕ್ಸಿಡೆಂಟ್ ಯಾವ ವರ್ಷದ್ದು? Because the compensation is being awarded now. So what is the money that 1,50,000 is equivalent to now? Ranaseti case ಅಲ್ಲಿ 10% every 3 years ಅಂತಂದ್ರು. That is not actually final. So ಆ ತಗೊಂಡ್ರೆ 1,50,000 ಎಷ್ಟಾಗುತ್ತೆ? ಡಬಲ್ ಮಾಡ್ಬೋದಾ? 3 lakhs. ನಾವು 1,50,000 ಮನಿ ವ್ಯಾಲ್ಯೂ ನೀವು ಹೇಳಿ ನಾನು ಅದರ ಆಧಾರ ಮೇಲೆ ಮೂವ ಅವತ್ತಿನ 1.5 ಲಕ್ಷಕ್ಕೆ ಇದೇ 1.5 ಲಕ್ಷ ತಪ್ಪಾಗುತ್ತೆ ಅಂತ. But Supreme Court has also held that notional income even in that second schedule has remained unamended, and that was also doubled in other cases. Then why should this remain static? Whatever amount is mentioned by the Supreme Court, let us assume it is to be accepted. Then that having related to the value of the money, we will double it or whatever, subject to what you say. My thinking was every year there is an inflation of about 6 to 7%. So 12 years have elapsed. 7 into 12, 100% ಆಗುತ್ತೆ. ನೋಡಿದಿರಾ ಅನಂತಕ್ಕೆ ಅವ್ರು ನೋಡಿದಿರಾ ಜಜ್ಮೆಂಟ್? ನೋಡ್ತೀರಾ? ನೋಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. Because this may have some implication. Yesterday I took a decision 30% ಅಂತ. But on rethinking, I think that amount needs to be determined. Next week. ಏನ್ ಮ್ಯಾಟ್ರ್? ಉಸ್ವದಿ ಕ್ಲೇಮೆಂಟ್ ನಮ್ಮ ರೆಕಾರ್ಡ್ ಕೊಡಿ ಅವ್ರು. ನೀವು ನೋಡಿ ಸರ್ ಸಾಕು, ನಾನು ಯಾವ್ದು ಬಂದ್ಬೇಡ. ನೋಡಿ ಏನಂತ ನೋಡಿ. 2014, therefore I'm asking you. So yes. What is injury suffered? Accident of the year? 17. ಎಷ್ಟಿತ್ತು 2017 ಅಲ್ಲಿ ಇನ್ಕಮ್? 2017 ಎಷ್ಟಿದೆ? 16 ಹೋಗಿದೆ. 17. What is the income for 2011? Disability 8% is correct. What is the injury? Who is the doctor who was examined? Private doctor. What was he? A producer driving license? So, that's the only thing, salary and 10%. Anyone? The claimant being dissatisfied with the compensation of 3,22,642 is an appeal. The fact that the accident occurred and the fact that the offending vehicle was insured is not in dispute. The tribunal or assessment of the evidence has awarded the compensation. The tribunal has assessed the disability of the claimant to 15.33% in the right lower limb and has therefore taken the whole body disability to be 8%. The claimant is stated to be an auto driver. The injury was to his right hip, for which he had to undergo a surgery. In my view, therefore, it would be appropriate to determine the disability at 10% as against 8%. The tribunal has come to the conclusion that the claimant was earning the sum of rupees 9,000 per month. Since there was no documentary evidence, as the accident is of the year 2017, it would be appropriate. Since there is no documentary evidence, it would be appropriate to adopt monthly income determined by the KSLSA, which for the year 2017, rupees 11,000. The claimant in age, what was his age? 40 years. The multiplier of 15 years. Consequently, towards loss of which income, the claimant will pay rupees 7,015 into 10%. The claimant, as a consequence, the amount of which is 27,000 awarded towards loss of income would also stand enhanced to rupees 33,000. In regard to the injuries suffered by the claimant, the amounts awarded towards pain and suffering and conveyance, food, nourishment, and charges would have to be marginally increased to rupees 50,000 and 10,000. The sums awarded under the other heads do not call for any interference and they are accordingly uniform. Consequently, the payments will be the following sums. Where is he? Can you get him at 1:30? Then I'll fix a date.
She had taken the she had given it to her husband, brother-in-law, and her brother. He lived abroad from Surya, English. At that time, it has fallen to a depth of 20. Now, his brother-in-law suffered a citizenship, and he is filed a claim petition. Now, in the claim petition, trial court did not see two documents. The first is the accident report accident. Wherein very clearly there is mentioned that owner of the vehicle subsequently not taking into consideration. And the other two documents, that is the delivery book, when it is signed, it is signed on the delivery book. I was arrested. Third one is a notice is given by the police station to the Lata saying that please give all the necessary documents as part of the. And she also replied to the notice saying that yes, I am the new owner. So these two documents have been used for the court. And in the final court also, the subsequent owner was not made a part. Hence, in the previous occasion, my application for completing the subsequent owner was allowed. And the subsequent owner was. So my main prayer is demand the matter so that I can cross examine.
Is the RC region transferred now?
Yes.
When was it transferred?
It's not for a meeting that I got.
Must the sale according to you?
22, 10.
And the accident?
Accident is my fault.
When is the notice given by the police?
Police. 311. I got a delivery note of it. Signed by the staff.
And the reply of that subsequent purchaser? When was that given reply? And 18th, it has been transferred. There's no dispute regarding the policy.
It is an AOP policy actually, which is not higher. Because vigilance have taken a contention that the company have done investigation and the subsequent owner Lata is the
What is the policy? Occupants of the car.
The parents to demand the matter so that it was exactly Lata.
What is the award? Have you deposited any sums here?
Yeah.
No, but in between your fights, the claimant should not suffer. She should get some compensation. You can always get this compensation from.
Lata's own brother-in-law, she paid for the subsequent owner. That is why I did. He demanded and he disposed of the 6
Here we are again.
This is subsequent owner.
Your brother-in-law caused the accident. Send it back. Yeah. If the sale is on 22/10/2015, they have, I think, 2 weeks or something to inform the RTO, isn't it? So it comes within that date. By 1811 is a formal transfer, but if they intimate it to them within the period permissible, then their liability comes to an end. I'll send it back. What are the additional documents? These were not produced. Anyone? The registered owner, the claimant, contends that he had sold the vehicle in question on 22/10/2015 in favor of Srimati Lata KS, the third respondent herein. It is stated that thereafter, the accident occurred on the 24th of October 2015 when the car was being driven by the brother-in-law of the third respondent. It is also stated that on 3rd of November 2015, the police had issued a notice to Lata, the third respondent, on the premise that she was the owner, and Lata, by her reply of the same day, acknowledged the fact that she had become the owner of the vehicle. It is also stated that the registration was transferred on 18/11/2015. The tribunal has, however, the said documents were, however, not produced before the tribunal, and the same have been produced before this court, and the third respondent has also been impleaded in this appeal. By the impugned award, the tribunal has come to the conclusion that the appellant herein was liable for the compensation of rupees 6,55,703 since she was the registered owner as on the date of the accident. In regard to the fact that the claimant has produced a delivery note indicating that the vehicle was delivered to the third respondent on 22/10/2015, and subsequently the certificate, and subsequently the registration has also been transferred within a period of on 18/11/2015, indicates that there has been a transfer of the vehicle. Since the tribunal did not have the benefit of these documents, it has come to the conclusion that the appellant was liable for the compensation. In my view, it would be the interest of justice if the matter is remanded to the tribunal, the direction of the tribunal to reconsider the entire matter, keeping in mind the documents that are now produced before this court, and also any further documents that may be produced by the appellant to indicate that he is not liable for the accident, and it is only the third respondent who would be responsible for the accident. The impugned order is therefore quashed, was set aside, and the matter is remitted to the tribunal. Direction to the tribunal to reconsider the matter afresh, the right of the observations made above, and dispose of the proceedings within a period of 6 months from the date of respective copy of this order. The amount and deposit shall stand transferred to the tribunal, and appropriate orders will be passed on the said amount and deposit, depending on the final outcome by the tribunal. ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? ಲೈಸೆನ್ಸ್ ಇಲ್ದಿರೋ ಬರುತ್ತಾ? ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರಲ್ಲಿ ಅವ್ರು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡೋಣ. Next week. Next ಅದೇನಾ? ಅವ್ರ ಪೇನ್ ರಿಕವರಿ ಆದ್ರೆ ಅವರೇ ಮಾಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋಡೋಣ. ಎಣ್ಣೆದಾ? ಕೊಟ್ಟಿದ್ರೆ ಗೌಡ್ರಿಗೆ? ಗೌಡ್ರು ಕೊಟ್ಟಿದ್ರೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್? ನೋಡಿದ್ರಾ? So he has drawn consistently ಮಾಡ್ಕೊಳ್ತೀವಿ ಬಿಡಿ, ನೀವೇ ತಲೆ ಕೆಡಿಸಿ. ಅವ್ರು ಕಟ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಮೋಸ. ಅವ್ರಿಗೆ ಏನಾದ್ರು ಕಾಸು ಕೊಟ್ಟಿದ್ರೆ ಆ ಕಂಪನಿ ಅವ್ರ ಜವಾಬ್ದಾರಿ TDS ಮಾಡೋದು. ಅವ್ರ ಆಯ್ತು TDS ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕಾಸು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಗುತ್ತೆ. TDS ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವನಿಗೆ ಫೈನ್ ಹಾಕ್ತಾರೆ. ಏನು ಕೊಡ್ತಾರೆ? ಓಕೆ, ನಾನು ಆವರೇಜ್ ಅವ್ರಿಗೆ ಅಂದಾಜು ಒಂದ್ 25,000 ರೂಪಾಯಿ ತಿಂಗಳ ಬರ್ತಾ ಇದ್ರೆ ಆವರೇಜ್ ನಾನು ಹೇಳ್ತಾರದು. ಅದರಲ್ಲಿ ಎಷ್ಟು ಖರ್ಚು ಹೋಗುತ್ತೆ, ಅವ್ನ್ಗೆ ಎಷ್ಟು ಉಳಿಯುತ್ತೆ ಅದನ್ನ ರೇಟ್ ಅಲ್ಲ ನೀವೇ ಹೇಳಿ. ಅದಕ್ಕೇನು ಆಯ್ತು, ಹಂಗಾರೆ ನಾನೇ ಹೇಳ್ತೀನಿ ಬಿಡಿ. I will hold that he had at least 50% profit and hold that he is getting 12,000 rupees here. ಅಲ್ಲಿ ಎಷ್ಟು ಬರ್ತಿದ್ ನಿಮ್ಗೆ ಕಮಿಷನ್? ಅಲ್ಲ ಬೆಸ್ಕಾಂ 12,000, 24,000, 12,000 ರೂಪಾಯಿ ಬರುತ್ತೆ ಅಂತ ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಇದಾನೆ. ಆಗುತ್ತೆ, ಪಾರ್ಟ್ ಟೈಮ್ ಕೆಲಸ. ಮೀಟರ್ ರೀಡ್ ಪಾರ್ಟ್ ಟೈಮ್ 10 ಗಂಟೆ 5 ಗಂಟೆವರೆಗೂ ಇಲ್ಲ. ಒಂದ್ಸಲ ಹೋಗಿ ಎಲ್ಲ ಮೀಟರ್ ಬರ್ಕೊಂಡ್ ಬರೋದು ಅಷ್ಟೇ, ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಎಲ್ಲಿದೆ ಆತರ? ಇಟ್ ಇಸ್ ನಾಟ್ ಇಟ್. ಮಾಡಲ್ವ ನೀವು 40 ಕೋಟಲ್ಲಿ ಓಡಾಡ್ತೀರಾ? ಅವರು ಅಷ್ಟೇ, ಅವರು ಮೀಟರ್ ರೀಡಿಂಗ್ ಮಾಡೋದು, ಬರೀ ಹೋಗ್ಬಿಟ್ಟು ಮೀಟರ್ ಬರ್ಕೊಂಡ್ ಬರೋದು. ನಿಮ್ಮನೆ ಮೀಟರ್ ರೀಡಿಂಗ್ ಮಾಡಕ್ ಬರ್ತಾನಲ್ಲ ಅವನು ಒಂದು ಹೋಗ್ಬಿಡ್ತಾನ. ಅವ್ನು 10 ಗಂಟೆ 5 ಗಂಟೆ ಏನ್ ಕೆಲಸ ಮಾಡಲ್ಲ ಯಾರು. That is why Bescom has appointed them on a part-time basis. Don't you think Bescom knows the meter reading job is a full-time job or a part-time job? Because for them to save money, if they were to employ a person on a full-time basis, only for meter reading, it will cost them a lot of money. Therefore, they appoint a person on part-time basis to save money. That indicates there is a circular which says minimum. That is why I gave you the option. You come out and give me a figure, I'll accept that. If you don't give me a figure, I'll accept 12,000 plus 12,000. This is the argument because these are all the documents. That is your argument. I'm telling you what my order will be. Before that, I'm giving you a chance. If you were to come out with reasonable. I will decide. Again, I'm not that I don't require your permission, but I'm just giving you an option. If you come out with reasonable sum, I'll accept that. If you don't, I'll go with whatever. That 12,000 rupees was on the basis of just a circular. Minimum 12,000. Now, according to him, he has earned about 24,000 rupees on an aggregate for more than 4 years. We will assume 50% is towards the cost of rearing those poultry chicken. So I said 12,000 plus 12,000, I make it 24,000. Bank statement is 2015 ಅಲ್ಲಿ bank statement ಕೊಟ್ಟಿದ್ರಲ್ಲ. That's why I'm telling you, I'm calculating on a 5-year basis. This is from 2012. The agreement is of the year 2007. So if he has a consistent job, consistent income from this particular company, I'll take judicial notice. It is not like a job where he is a government servant, where salary is paid every 31st. This is an agreement by which he is to take care of the poultry farm. He'll be paid on a cost basis or on whatever basis. He has indicated that he has drawn so much of money. ಯಾವ್ದು ಎಕ್ಸಿಬಿಟ್ ಇದು? Feed. How old was the deceased? 38 years. Anyone? The claimants are the wife, children, and mother of Prabhakar HC, who was killed in an accident, motor vehicle accident, on 12th of April 2016. For the death of Prabhakar HC, the tribunal has awarded a total sum of rupees 13,69,525. Being dissatisfied with the said sum, the present appeal is preferred. The tribunal has come to the conclusion that the deceased was working on a commission basis with MESCOM, and the evidence on record indicated that he was paid a sum of rupees 4,515 as commission. Was being paid commission, and the tribunal has considered the documents produced and concluded that on an average he was earning a sum of rupees 4,515 as commission. The tribunal has also recorded a finding that he was growing and supplying chicks, out of which he was earning a sum of rupees 5,000. in all, the tribunal has concluded that the deceased was earning a sum of rupees 9,550. And after deducting 1/4 and applying the multiplier of 15, is awarded a sum of rupees 12,84,525 towards loss of dependency. The learned counsel for the claimant contends that the reasoning of the tribunal in arriving at the monthly income of the deceased at rupees 9,550 is unsustainable. He seeks reliance upon the circular, relies upon the circular issued by MESCOM which is in relation to payment of heading relation to the terms of emoluments to be paid to the micro feeder franchisee according to as per Exhibit P20, Clause 4 of Exhibit P21. The meter reader was to be paid a minimum sum of rupees 12,000. And having regard to this circular, the tribunal ought to have taken the income of the deceased from MESCOM at rupees 12,000 and the determination at rupees 4,550 was wholly incorrect. He also submits that in addition to working as a part-time meter reader, the claimant was admittedly engaged in the business of rearing chicks and supplying them to a company. He submits that the claimant had also produced an agreement entered into with the said company in this regard, year 2007, as Exhibit P22. He submits that a bank statement was also produced, indicating that periodical payments for a period of nearly 4 years were made, totally amounting to rupees 10,57,579. And this would indicate that he was securing a sum of about rupees 24,594 on an average every month from the said company. He therefore submitted that the tribunal ought to have determined the income at rupees 36,000 per month as against 9,515. Learned counsel for the insurer, Sri B.C. Shivanegowda, on the other hand, vehemently contended that it is only impermissible for the claimant to contend that he was earning a sum of rupees 36,000 per month. He submitted that the actual payment received by the claimant as commission, as per the evidence on record, was only rupees 4,515. And therefore, reliance could not be placed on a circular which was fundamentally prospective in nature and did not indicate the actual sums that the claimant was receiving from MESCOM. He also submitted that the sums received by the claimant from the company called a company as Lifeline Feeds India Private Limited could not be considered as a regular income. And he also submitted that the sums paid by the company were towards the cost of rearing the chicks also. And therefore, the entire sum received by deceased could not be construed as his income from the company. In the light of the contentions advanced, it will have to be considered as to whether the determination of monthly income by the tribunal at rupees 9,515 was just and proper. Varsha, ಯಾವ ವರ್ಷದ accident ಇದು? The evidence on record as assessed by the tribunal indicates, confirms the fact that the claimant was working as a part-time meter reader and was also engaged in the business of rearing broiler chicks. The accident occurred in the year 2016 and reliance is placed on the circular of the year 2000, circular dated 10th of June 2016. The circular sought to incorporate the following clause in the agreements with the franchisee as regards payment of incentive to the meter readers, and the same reads as follows. The reading of the said circular indicates that a sum of rupees 12,000 was the minimum amount that was required to be paid to a meter reader as incentive on compliance of the conditions stipulated therein. This indicates that MESCOM was conscious of the fact that the meter readers who had been engaged by the franchisees were required to be paid at least a sum of rupees 12,000 for the services rendered by them. And in regard to the fact that the circulars of the year 2016 and the accident is also of the year 2016, it can be safely assumed that the claimant was entitled to get the sum of rupees 12,000 at about the time of his death. Death yavagagida? It is also to be noticed here that the claimant passed away just 2 months prior to the passing of issuance of the said circular. It would be therefore be proper to adopt the income stated in the circular as the income that the claimant was deriving from MESCOM. Apart from the said income as a part-time meter reader, the claimant has also produced an agreement that he had entered into, that the deceased had entered into with Mrs. Lifeline Feeds India Private Limited. The purpose of the agreement indicates that the deceased was to provide his own farm with all necessary infrastructure for the purpose of growing broiler chicks and provide to the company at his cost chicks. Clause 8 of the said agreement reads as follows. Thus, the claimant had a specific commitment from Messrs. Lifeline Feeds to supply chicks or broiler chicken for an amount which was mutually fixed based on the performance of the deceased towards rearing charges, which was to be determined on the basis of the weight of the grown chicken. The agreement also stipulates that it would come into force, it would be in force for a period of 5 years commencing from 1st of December 2008. And the claimant has produced the payment details separately, and also, more importantly, the bank statement as Exhibit P24. The bank statement indicates that the following payments were made from the period 10/1/2012 up to 24/5/2016, and the same are incorporated for the sake of clarity. Mark ಮಾಡಿದ. ಮಾತ್ರ The bank statement indicates that the deceased had received a sum of rupees 10,57,759 for a period of 43 months. And this would indicate that he was getting on an average sum of approximately 24,594 every month. Assuming that the claimant, the deceased, was incurring cost towards rearing of the chicken, it will have to be assumed that he would have a profit of at least 30% of the said sum of rupees 24,000. In other words, from the income from the business of rearing broiler chicken, it can be safely assumed from the bank statement, which indicates payments for almost 4 years, the claimant would definitely be earning a sum of rupees 8,000 per month on an average. In this view of the matter, the finding of the tribunal that the deceased was earning only rupees 9,515 per month cannot be accepted. The same is accordingly set aside. The monthly income of the deceased is hereby determined as rupees 12,000 plus 20,000 rupees per month. The deceased was aged 38 years and would hence be entitled to a multiplier of 15 to the said sum of rupees 20,000. Future prospects 40%. The claimant would also the sum of the 40% would have to be added towards future prospects, which would result in the monthly income to be rupees 28. 58,000. Out of the said sum, 1/3 would have to be deducted towards his personal expenses. 1/4 is to be deducted, which would result in a monthly income to rupees so and so. As a consequence, the claimant should be entitled to some more rupees towards loss of dependence. In addition, the claimants being the wife, children, and mother, each of them would be entitled to some rupees 44,000 towards loss of consortium, and also some rupees 33,000 towards under the conventional rates. In all, some rupees so and so would be liable to be paid by the insurer. Appeal is accordingly allowed.
The claimant's appeal for enhancement as well as the KSRTC also filed the appeal. Since I am already permitted to withdraw 50% of the award amount, I filed an IA for return of LCR. But it may be disposed of, my lord, because they.
In ಯಾವ ground ಮೇಲೆ appeal? Negligence. Accident between
Bus and motorcycle.
the negligence in point. Was riding a two-wheeler. Sketch idea.
The KSRTC bus, BMTC bus dashed from behind, my lord.
ಅವ್ರೇನು highway report ಇಲ್ಲ ಅಂತ ಅಂತಾರೆ ಆತರ ಇಲ್ಲ.
ಅಲ್ಲ ಅದಕ್ಕೂ ಡ್ಯಾಮೇಜ್.
Injuries ಏನೇನಾಯ್ತು?
My lord, may I submit, my lord? My lord, is a comminuted fracture of.
ಅವ್ರು ಹೇಳ್ಬಿಡ್ಲಿರಿ ಹೇಳ್ತಾರೆ. ಹಾ. Seven days. The injuries ಏನಂತ ಹೇಳಿ.
Comminuted fracture of left tibia and fracture of jagamatic bone and facial injuries. The 57 years running a sweet stall. If my lord permits, I will. Photos also produced.
ಇನ್ಕಮ್ ಸರಿ ಇದೆಯಾ?
ಇಲ್ಲ ಇನ್ಕಮ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ತಗೊಳ್ಬೇಕಾಗ್ತದೆ. ಅವರು ಕಡಿಮೆ ಆಗಿ ಜಾಸ್ತಿ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. There is some income tax returns produced for the year 2017-18 shows 2,68,300 per year. That is 2013 in January 2019.
ಅದರ ಹಿಂದಿಂದ ಇದೆಯಾ?
ಅದ್ರ ಹಿಂದಿಂದು ಅದೇ 2017-18 ಅದು 22,358 per month ಬರುತ್ತೆ. 15,000 ತಗೊಂಡಿದ್ದಾರೆ.
17-18 earlier periods ಇದೆಯಾ?
ಒಂದೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
When was the returns filed?
It is for the year assessment year 2017-18.
When was it filed? After the accident or before? The accident?
Before accident. Say, my lord, may I submit, my lord? My lord, he is aged 57 years, running a sweet stall. To prove his income, occupation, shop registration certificate and trades license is also produced.
Did he own the
Income
shop?
tax-
Did he own that property? Did he own that property?
Yes, here after the accident, my lord, I will come to that point. My lord, the injury sustained is comminuted fracture of left tibia and fracture of zygomatic bone and injuries to face. But what happened is immediately after the accident, MS Ramaya Hospital, thereafter shifted to Manipal Hospital for 7 days, underwent 2 surgeries. Incurred about 7,74,500 is the medical bills produced that has been accepted. Only 50,000 denied without giving any reason. But the present condition of the appellant is very important. But while giving the evidence after 7 months, well, our court recorded a finding that this one, while giving the evidence, he was on the wheelchair. Well, and the doctor evidence is there is a non-union. And there is a 3 centimeter gap between the fractured side and required a total knee replacement and also corrective surgery is needed. That is the evidence on record, Mallard. According to Dr. Mallard, there is a 28.58% whole body disability, 19% is considered. Mallard, my respectful submission is, Mallard, the pain and suffering 45,000 seems to be lower side. And also loss of immunity is 20,000. Considering the subsisting disability and now present condition of the appellant at the age of 57 years, that is non-union, and also 3 centimeter gap between this fractured side between 2 bones, 20,000 seems to be lower side. As well as medical expense is concerned, the tribunal after consideration of this 6,80,300 medical bills, plus a physiotherapy bill 72,600 and another 21,600 bill, while totalizing 70,000 ಜಾಸ್ತಿ 72,000 ಜಾಸ್ತಿ ಆಯ್ತು ಅಂತ ಹೇಳಿ 20,000 ಇಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಒಂದು ಟೋಟಲ್ 7,74,500 ಆಗಬೇಕು, 7,71,900 ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಲ್ಲೂ ಕಡಿಮೆನೆ ಕೊಟ್ಟಿದ್ದಾರೆ. And incidental 10,000, loss of earning 45,000 is considered. But main thing is, my lord may kindly see at the time of giving evidence also, doctor evidence as well as the giving petitioner evidence, enter into witness box by sitting in a wheelchair. That is why that period, it comes to extent is 13/1/2019 and evidence is on 37/2019. More than 6 months, 7 months on record is constrained to wheelchair. That is why this absolute loss period is to be extended to some extent. And next to head is future loss. Well, 15,000 is considered. Well, the income tax return shows Melaz is 2,68,300, and after the accident, well, it is borne on record that he has given the evidence in cross-examination that his son, since he is constrained to this wheelchair, their son is continuing the shop. They are running the shop. Now, Melad, if earning capacity is considered, 2,68,300 divided by 12 months, it comes to 22,358. It is left to the court. 15,000 ತಗೊಂಡಿದ್ದಾರೆ. But 19% seems to be very low because 24.32% plus 45%, it comes to 57.16%, and 28% whole body ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್. That is to be as far as future losses, future medical expenses, 30,000 is awarded, but according to doctor, it requires more than about 2 lakhs rupees. ಎರಡು ಸರ್ಜರಿ ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. Amount.
This doctor has treated him?
No, he is not treated. He is only assessed the disability. To prove the line of treatment, I produced the medical record through PW3.
Where is the discharge summary?
Discharge summary, a lot of medical records, all medical records produced. Discharge summary, exhibit P7 is the discharge summary. photos also produced to show the present condition of the appellant.
When was the accident, you said?
My lord, 13/1/2019, 7 days inpatient. Medical expense 7 ಲಕ್ಷದ ಮೇಲೆ ಇದೆ. Total put is 11 lakhs.
This is summary P7.
Exhibit P7 ಅಂತ ನನ್ನ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ. P7 annexures.
MS Ramaya, where did you go?
Manipal Hospital.
Where is that discharge summary?
ಅದೇ ಆಗಿರ್ಬೇಕು. ಕರೆಂಟ್ ಹೋಯ್ತು ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು 1 minute ಹೆಚ್ಚು ಕಮ್ಮಿ ಆದ್ರೂ ಆಗ್ಬಹುದು. ಕರೆಂಟ್ ಹೋಯ್ತು, ಬರ್ತದೆ, ಜನರೇಟರ್ ಚಾಲು ಮಾಡ್ತಾರೆ.
P7 is Ramaya. Where is Manipal Hospital?
Manipal Hospital, my lord, I produced through PW3.
Exhibit ಏನು?
ಅದು ಟೋಟಲ್ ಇಡೀ ಸೆಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ. ದಟ್ ಈಸ್ ಮಾರ್ಕ್ಡ್ ಆಸ್ ಎಕ್ಸಿಬಿಟ್ P18 to 19. ಕೇಸ್ ಶೀಟ್ 19.
Second discharge summary ಇಲ್ವಾ?
ಅದರಲ್ಲಿ ಕೇಸ್ ಶೀಟ್ ಅಲ್ಲೇ ಇರುತ್ತೆ ಸ್ವಾಮಿ. ಎಕ್ಸಿಬಿಟ್ P19 ಅಲ್ಲಿ ಕೇಸ್ ಶೀಟ್ ಅಲ್ಲೇ ಇರುತ್ತೆ. ಅವ್ರ ಕಾಪಿ ಬೇಗನೆ ಮಾಡೋಳೆ.
Discharge summary ಇಲ್ವಾ ಇಲ್ಲಿ? ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್ ಇಲ್ವಾ?
ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್ ಕೇಸ್ ಶೀಟ್ ಇದ್ರ ಪ್ರೊಡ್ಯೂಸ್, ಇಡೀ ಕೇಸ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಇರುತ್ತೆ ಎಕ್ಸಿಬಿಟ್ P19 ಕೇಸ್ ಶೀಟ್. ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್ ಎಕ್ಸಿಬಿಟ್ P19 ಸೆಟ್ ಅಲ್ಲೇ ಇದೆ ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ.
Not able to see that.
P19 ಇಡೀ ಕೇಸ್ ಇದನ್ನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ.
Recovered well ಅಂತ ಇದೆಯಲ್ಲ ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿಯಲ್ಲಿ ವಿತ್ ಫಿಸಿಯೋಥೆರಪಿ ಶಾಸ್ತ್ರಿಗಳ.
My lord, my lord, the ಚೆಕ್ ಎಕ್ಸ್ರೇ ಅಂದ್ರೆ ಅವ್ರ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಆಫ್ ಮೂವ್ಮೆಂಟ್ ಇದಾಗಿರ್ಬೇಕು, ಸರಿಯಾಗಿರ್ಬೇಕು. ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಆಫ್
ಇವ್ರು ಯಾರು ಬಂದು ಡಾಕ್ಟರ್ ಹೇಳಿದ್ರೆ ಅದೇನೋ ಒಂದ್ ಇರ್ತಿತ್ತು.
ವೀಲ್ ಚೇರಿಗೆ ಹಾಕೊಂಡು
ವೀಲ್ ಚೇರ್ ಅಲ್ಲಿ ಬಂದಿದ ತಕ್ಷಣ
ಕೋರ್ಟ್ ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ ನೋಡಿ ಸರ್. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ
He was discharged within 6 days of Manipal Hospital.
7 days.
Bill.
ಅಲ್ಲಿ ಮತ್ತೊಂದು ಹೇಳ್ತೇನೆ, ಮತ್ತೊಂದು ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ವಾಕ್ಸ್ ವಿತ್ ದ ಸಪೋರ್ಟ್ ಆಫ್ ಎ ವಾಕರ್ ಫ್ರೇಮ್ ಅಂತಿದೆ.
It is not found in the discharge summary where you got operated.
Immediately after the this treatment.
Word here you used here is he was started on physiotherapy in post-op period and recovered well with physiotherapy. Dressing was done on 2nd, 5th post-op days and the wound was found to be clean and dry. Patient is symptomatically better and has been discharged with the treatment ways.
Comparatively better, that is a word. ಯಾಕಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಗ್ಯಾಪ್ ಇದೆಯಲ್ಲ, 3 ಸೆಂಟಿಮೀಟರ್ ಗ್ಯಾಪ್ ಇದೆ. That is the that
non-weight bearing mobilization with walker ಅಂತ ಇದೆ. And he has undergone physiotherapy even up to ಎಲ್ಲ physiotherapy bill alle
70 bill 70 that is a exhibit P 14, exhibit P 14 physiotherapy treatment 72,600.
He has produced exhibit P16 the doctor said patient always limps and walks slowly with support of a walker. 2 surgical sutures are present and this was given 2019. 2017 accident, 2019 Victoria Hospital says July 19 allo they are saying even after 6 months he's still walking with a walker. ಇಲ್ಲಿ Victoria Hospital ಇದೆಯಲ್ಲ, no, there is a Victoria Hospital medical record. No, see this please see P16, that's a record of the government hospital. Then why should we disbelieve it? No, but he has recorded a finding that he is walking with a walker 6 months after the accident. ಎಷ್ಟು ಹೊಂದಿದ್ದಾರೆ ಇಲ್ಲಿ ಡಿಸಬಿಲಿಟಿ?
19% ಟ್ರಯಲ್ ಕೋರ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ಡಾಕ್ಟರ್ ಹೇಳಿದ್ರೆ 28%, ಜಾಸ್ತಿ ಏನು ಹೇಳಿಲ್ಲ ಅವರು.
Permanent physical residual physical disability of about 28.58% of whole body. Now, this is the evidence I am reading of PW2, Dr. S. Ramchandra, Assistant Professor of Orthopedics at Victoria Hospital. ಎಷ್ಟು ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ 20%.
ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದು 19%. ಇದು ಡಾಕ್ಟರ್ ಹೇಳೋದು 28.58%, ಅಂದ್ರೆ 29%.
Ultimately, the conclusion is 28.58 to the whole body. For whatever reason, the doctor said is 28.58%. Government doctor stock witness. Assistant Professor of Victoria Hospital, are you saying is a stock witness? Because I need to know. I will not rely upon it if that is so. Shastrigale,
My lord.
this doctor has not treated him.
Yes.
He has only assessed the disability. Why should I accept his report that he was walking with a walker?
ಯಾಕಂದ್ರೆ ಮೊದಲನೇದಾಗಿ ಇದ್ರಲ್ಲೂ ಅವನು ಕೋರ್ಟಿಗೆ ಬರ್ಬೇಕಾದ್ರೂ ಈಸ್ ವಾಕಿಂಗ್ ವಿತ್ ದ ವಾಕರ್. ಆಮೇಲೆ ಫಿಸಿಯೋಥೆರಪಿಲೂ ಇದೆ, ಆಮೇಲೆ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್.
Have you examined the physiotherapist?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಮಾಡಿ.
What is because the discharge summary of the Manipal hospital does not, the finding recorded is ಎಷ್ಟು ದಿನ ಅಂತ ಬರ್ದಿಲ್ಲ ಅವರು. Non-weight anti-TVT exercise, calf pumps, active 2 moments, non-weight bearing mobilization with walker. Review with Dr. Sunil.
ಅವಾಗೂ ವಾಕರೇ ಅವನಿಗೆ.
ಇಲ್ಲ, discharge ಆದಾಗ ಅದಾದ್ಮೇಲೆ what did you go back to this Manipal hospital with for a review? Is there anything to show that they reviewed you and you continued the same?
ಇಲ್ಲ, ಹೇಳಿದಾರೆ ಹೇಳೋದ್ ಬಿಟ್ರೆ ಮತ್ತೆ ಏನು ಮಾಡೋದು? ಕೇಸ್ ಶೀಟ್ ಅಲ್ಲಿ ಅದಿದ್ರೆ ಎಕ್ಸಿಬಿಟ್ P4 ಇದರಲ್ಲಿ 18 ಅಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P18 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಇರ್ತದೆ, ಕೇಸ್ ಶೀಟ್ ಆಫ್ ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್.
ಅದ್ರಲ್ಲೇನು ಇಲ್ಲ, ವಾಪಸ್ ಫಾಲೋ ಅಪ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಇಲ್ಲ. After Manipal, you gone to Victoria Hospital and this gentleman, this doctor who has given this evidence is the person who has made this entry, tane? He has prepared this as an outpatient record.
Yes.
He had never treated him. ಅದು ಮೇಂಟೈನ್ ಮಾಡೋಣ 20% ಹಂಗೆ ಇರಲಿ.
ಇನ್ಕಮ್ ಆದ್ರೂ ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ, ಯಾಕಂದ್ರೆ ಪಾಪ ಅದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ, ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದೇನೆ, ಶಾಪ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ಯಾಲರಿ? 15,000
ತಗೊಂಡಿದ್ದಾರೆ. ಅವಂದೇ ಸ್ವಂತ ಅಂಗಡಿ ರನ್ನಿಂಗ್ ಈಗ ಮಕ್ಳಿಗೆ ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ, ಮಕ್ಕಳ ರನ್ನಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ನಮ್ ಚಾರ್ಟ್ ಪ್ರಕಾರನೇ ಫಾರ್ ಮಿನಿಮಮ್ 14,000 ರೂಪಾಯಿ ಇದೆ. ಈ ಬಿಸ್ನೆಸ್ ಗೆ ಈಸ್ ಇನ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಅಸೆಸ್ಸಿ. ಸಾಕು ಇರ್ಲಿ, 1 ವರ್ಷ ಆದ್ರೆ ಅವನು 20,000 ರೂಪಾಯಿ ಸಂಪಾದನೆ ಮಾಡಿದ್ರೆ ತಿಂಗಳ ಇಲ್ಲ. ಇಫ್ ಇನ್ ದ ಇಯರ್ 2017 ಈಸ್ ಅ ಬಿಸ್ನೆಸ್ ಮ್ಯಾನ್, ರೈಟ್? ಬಿಸ್ನೆಸ್ ಮ್ಯಾನ್ 2 ಲಕ್ಷ ತೋರಿಸ್ತಾ ಇದ್ರೆ ಇನ್ಕಮ್ ಖಂಡಿತ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇರುತ್ತೆ. ಏನಾರು ಇಟ್ಕೊಳ್ಳಿ, ಅವ್ನು ಇನ್ಕಮ್ ಅಷ್ಟು ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ತಗೊಳ್ಳಿ, ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಳ್ಳಿ ಹೇಳಿ, 15,000 ರೂಪಾಯಿ ಕಮ್ಮಿ ಆಯ್ತು. ಬಟ್ ಒಂದ್ ಸ್ವೀಟ್ ಅಂಗಡಿಯಲ್ಲಿ ಅವನಲ್ಲಿ ಒಂದೇ ಕಡೆ ಕೂತಿದ್ರೆ ಕೆಲಸ ಮಾಡಲ್ಲ ಕೆಲಸ. He has to have active involvement in that. I will maintain that 20%. Income ಎಷ್ಟು ತಗೋಬೇಕು ಹೇಳಿ? ಇಲ್ಲ 15,000 ರೂಪಾಯಿ ತಗೊಂಡಿದ್ದಾರೆ. ನಿಮ್ ಕ್ಯಾಟ್ ಪ್ರಕಾರ 14,000 ಇದೆ. ಎಷ್ಟು ತಗೊಳ್ಳಿ ಹೇಳಿ? 15,000 ರೂಪಾಯಿ ಮೇಲೆ ಒಂದು ಫಿಗರ್ ಹೇಳಿ. ನಿಮ್ ಕರೆಕ್ಟ್ ಅನ್ಸಿದೆ. ಆಯ್ತು, ಆರಿಮ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ. ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೋಬೇಕು ಹೇಳಿ ನಿಮ್ ಪ್ರಕಾರ? I'll take 20,000. Since you are not offering any sum, take it as 20,000. He's a businessman, he's got a trade license. Let us assume it is a family business. He was taking care of it. Now his son is forced to come. Then 20,000 ತಗೊಳ್ತೀನಿ. ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಮನ್ನು ಕೇಳಿದೆ ಎಷ್ಟೊಂದು ಅಮೌಂಟ್ ಹೇಳಿ ಅಂತ, ನೀವು ಅದನ್ನ ಹೇಳಲಿಲ್ಲ. ಅದಕ್ಕೆ ನಾನು 20,000 ತಗೊಳ್ತೀನಿ. $18,000 ತಗೊಳ್ತೀನಿ.
22,000 ಬರುತ್ತೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಪ್ರಕಾರ. ಇಟ್ ಈಸ್ ಲೆಫ್ಟ್ ಟು ದಿ ಕೋರ್ಟ್. ನಿಮ್ಗೆಲ್ಲ ಗೊತ್ತಿದೆ, ನಾ ಏನ್ ಹೇಳೋದು. 20,000 ತಾಳ್ಬಹುದು ಅನ್ನೋಳು ಅನಿಸ್ತಾ ಇದೆ. ಮೆಡಿಕಲ್ ಬಿಲ್ ಅಲ್ಲಿ ಒಂದು 70,000 ಜಾಸ್ತಿ ಆಗಿತ್ತು ಸರ್. 50,000 ಜಾಸ್ತಿ ಆಗಿತ್ತು.
ಅದು ನಿಮ್ಮ ಅಂಗಡಿ ಸ್ವಂತನೇ ಬಾಡಿಗೆನ?
ಸ್ವಂತ 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 ಅಂತಲೇ ಇದೆ. ಅಂದ್ರೆ ಬಾಡಿಗೆನ ಇದು ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ರನ್ನಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದೆ.
ಸ್ವಂತ ಅಂದ್ರೆ ಅವ್ನು ಚೆನ್ನಾಗಿ ಸಂಪಾದನೆ ಮಾಡಿರ್ಬೇಕಲ್ಲ. ಬನ್ನಿ ಮೇಡಮ್. MFA 3379/2020 is by the BMTC challenging the award of compensation both on the ground of negligence and also as against quantum. MFA 1422/2020 is by the claimant seeking for an answer. The case of the claimant was that while he was riding his two-wheeler, he was hit from behind by the BMTC bus, resulting in grievous injuries to him, as a result of which he had to undergo treatment at MS Ramaya Hospital and also at Manipal Hospital, and also subject himself to surgeries. The claimant contended that he was entitled for a compensation of rupees 75 lakhs, and he was earning about 50,000 rupees a month. The tribunal, on assessment of the evidence, has come to the conclusion that the injuries, that the accident occurred only due to the rash and negligent driving of the driver of the BMTC bus. It is also recorded a finding that the claimant has suffered 20% permanent disability to the entire body and ultimately awarded the following sums. Is a case of Sri Sripat Shastrinath Council for the claimant. The Council for the Corporation. That the finding by the tribunal that the accident occurred with the negligence of the driver of the BMTC bus cannot be accepted. He sought to contend that there was no evidence to indicate that the collision was at the rear end of the two-wheeler, and the IM report did not support this contention. Sketch ಯಾವುದು? Sketch ಇಲ್ಲಿ sketch. Where is the sketch?
P3 Miller.
The result of the sketch, which is produced exhibit P3, indicates that the claimant was driving on the left side of the road and the bus collided with him. The bus which was traveling on the middle of the road collided with him on the left side of the motorcycle of the two-wheeler. This indicates that the bus driver basically hit the two-wheeler on the left side of the two-wheeler. With regard to the fact that the two-wheeler is shown to be traveling on the extreme left side of the road, it is quite but obvious that the accident occurred due to the negligence on the part of the driver of the KSRTC bus, who appears to have suddenly come to the left and had an impact with the two-wheeler. Where is the evidence? Avada driver madidra?
ಹೌದು ಹೌದು RW1.
Is also to be noticed here that the police, after investigation, have charge sheeted the driver of the BMTC bus, thereby indicating that the driver of the bus was responsible for the accident. The driver of the KSRTC bus has overstated that the rider of the two-wheeler hit the rear right side of the bumper of the KSRTC bus, of the BMTC bus. This affidavit contradicts the sketch prepared and also the damage that is indicated in the IMA report. In regard to this evidence that was adduced by the tribunal, in my view, the tribunal was justified in arriving at the conclusion that it was the driver of the BMTC bus who was responsible for the accident. The said finding is accordingly affirmed. The tribunal has determined the monthly income of the claimant at rupees 45,000
ಅಲ್ಲಲ್ಲ 15,000.
rupees per month. The claimant had admittedly produced the income tax return for the financial year 17-18,
ಹೌದು 17-18 2,68,300. It shows.
17-18, which was a period prior to the accident, which indicated that he had filed a return indicating that his annual income was rupees 2,63,000.
68,300.
68,300.
That is 22,358 per month.
2 years prior to the accident, the claimant was earning on an average over rupees 21,000.
22,358.
Over, this is noticed here that the said income includes income from bank FDs and also from agriculture income. Having regard to the computation of income shown in the IT returns, we appropriate to consider the income of the claimant at rupees 18,000 as against some rupees 15,000 determined by the tribunal. The tribunal has determined the disability at 20%, alva?
19%. 19%.
On
ಅಂದ್ರೆ non-union ಇದೆ, shortening 3 centimeter shortening ಇದೆ.
the doctor who had deposed before the tribunal has stated that the claimant had suffered 28.5%, 28.58% is to the whole body. And it suffered disability of 57.16 to the left lower limb. The evidence on record, the medical discharge summary of Manipal Hospital indicates that at the time of discharge, the claimant was advised to have non-weight bearing mobilization with walker, indicating that he would need the assistance of a walker. The claimant has also produced a physiotherapy bill. The physiotherapy the exhibit?
My lord, second further, so exhibit P. 14, exhibit P14 is a physiotherapy treatment, 72,600. ಆಮೇಲೆ ಇನ್ನೊಂದು ಎಕ್ಸಿಬಿಟ್ P20 ಮೆಡಿಕಲ್ ಬಿಲ್ 21,600 ಎರಡು ಇದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಎಕ್ಸಿಬಿಟ್ P14 72,600.
ಎಲ್ಲಿದೆ ಅದು?
ಎಕ್ಸಿಬಿಟ್ P14 ಟ್ರೀಟ್ಮೆಂಟ್ ಬಿಲ್ ಸೇಲ್ ಟ್ಯಾಕ್ಸ್ ರಿಸಿಟ್ ಗಿಂತ ಮೊದಲು.
Indicating that he had undergone physiotherapy the month of March, April, and May, and he had made more than month of March, that is 29 visits, April 19 visits, and May 24 visits. This indicates that the petitioner has suffered June, July, indicating that the disability was prevalent right up to July, and the claimant had to virtually undertake physiotherapy every day. The date of this evidence, in my view, to be appropriate to consider the total body disability at 25% as against 19% determined by the tribunal. As a consequence, the claimant would be entitled to sum of rupees 18,000 to 12. Yes, multiplier ಎಷ್ಟು?
9, my lord, 9.
25%. Towards loss of this income. The claimant, the tribunal has awarded sum of rupees 45,000 towards pain and suffering and rupees 20,000 towards loss of benefits, and a sum of rupees 10,000 towards punishment, conveyance, and charges. And with regard to the fact that the claimant had to undergo physiotherapy for more than 6 months, it will be appropriate to enhance the amount compensation towards pain and suffering, is 45,000 to 1 lakh, and also enhance the amounts awarded towards loss of amenities from 20,000 to 50,000. And with regard to the fact that the claimant has been undergoing conveyance for 6 months, the amounts awarded towards nourishment conveyance would also have to be enhanced to rupees 50,000. Current counsel for the claimant contended that the sums awarded towards medical expenses did not take into consideration sum of rupees 50,000.
ಸುಮಾರು 7,21,900 ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. ಟೋಟಲ್ 7,74,500 ಆಗುತ್ತೆ ಟೋಟಲ್.
ಯಾವ ಬಿಲ್ ಒಮಿಟ್ ಮಾಡಿದ್ದಾರೆ?
ಇದು ಫಿಸಿಯೋಥೆರಪಿ ಬಿಲ್ 72,600 ಅಲ್ಲಿ 20,000 ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಓನ್ಲಿ ಆನ್ ದ ಫೈಂಡಿಂಗ್ ದಟ್ ಇಟ್ ಸೀಮ್ಸ್ ಟು ಬಿ ಹೈಯರ್ ಸೈಡ್.
Some of rupees 43,200 towards physiotherapy.
ಫಿಸಿಯೋಥೆರಪಿ 72,600 ಅಲ್ಲಿ 20,000 ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಟೋಟಲ್ 7,74,500 ಆಗ್ಬೇಕು.
On 6,19 was only taken into consideration. Below rupees 49,000 crore. Take it 29,700,000. This will be the compensation towards medical. ಒಟ್ಟು ಬಿಲ್ ಇರೋದು 43,200 ಪ್ಲಸ್ 29,400.
ಮತ್ತೆ 21,000 ಮೆಡಿಕಲ್ ಸಬ್ಮಿಟ್ ಮೇಲೆ
ದಿನಕ್ಕೆ ಇಷ್ಟ ಅಂತ ಚಾರ್ಜ್ ಮಾಡಿರೋದು ಅವ್ರು. ಅಲ್ಲ ಬಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಎರಡೂ ಇದೆ.
ಟೋಟಲ್ ಅಲ್ಲ ಮೈ ಸಬ್ಮಿಟ್ ಮೇಲೆ ಟೋಟಲ್ 7,74,500 ರೂಪೀಸ್ ಆಗುತ್ತೆ ಮೆಡಿಕಲ್ ಬಿಲ್ಲು ಮತ್ತೆ ಫಿಸಿಯೋಥೆರಪಿ ಬಿಲ್ಲು. ಅವ್ರು ಕೊಟ್ಟಿ 7,21,900.
ಜಾಸ್ತಿ ಮಾಡಿ 50,000 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಮಾಡ್ತಾ
ಆಯ್ತು.
medical expenses financed by further sum rupees 50,000. Payment to be entitled to total sum of rupees.
ಅಲ್ಲ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಆಕ್ಷನ್ 30,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಬರ್ತೀನಿ ಯಾಕೆ ಇಷ್ಟು 7,71,000. As I've determined the monthly income at rupees 18,000. The loss of income. The tribunal has taken the data period as 3 months. Since the evidence on record indicates that the claimant had been undergoing physiotherapy daily for over 6 months. It have to be held that data period for the claimant be a period of 6 months. As I've determined the income at 18,000, the loss of income data period would be a sum of rupees. Again, future medical expenses, sir.
ಅದರಲ್ಲಿ 30,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಡಾಕ್ಟರ್ 2 ಸರ್ಜರಿ ಆಗ್ಬೇಕು, ಕರೆಕ್ಟಿವ್ ಸರ್ಜರಿ ಆಗ್ಬೇಕು. ಎಷ್ಟು ಇಲ್ಲ ಹೇಳಿಲ್ಲ ಎಷ್ಟು ಅಂತ ಹೇಳಿ 30,000 ಸಿಮ್ಸ್
ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅವ್ರು ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಹೇಳಿಲ್ಲ ಸರ್ ಹೇಳಿಲ್ಲ.
ಈ sum of rupees 30,000 towards future medical expenses. Admittedly, the doctor has not stated as to what is the amount that would have to be spent on future medical expenses. The revenue was therefore justified in awarding only sum of 30,000. The appeal filed by case of the appeal filed by the claimant is allowed in part. The compensation owed to the claimant shall carry an interest at 6% per annum.
and the records forthwith.
Liability admission matters 42 to
43 serial number 43. I am first time ಬಂದಿದೆ, ಸ್ಟೇ ಬೇಕಾಗಿದೆ ಅಂತ ಪ್ರೇಡ್ ದಿಸ್ ಕೋರ್ಟ್ ಮೇಲೆ ನೋಟಿಸ್ ಮಾಡಬೇಕು.
ಅಲ್ಲಿ ಬರೀ ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ 48 to 50 51
43 my lord.
Entire compensation before this court.
43 my lord.
50% ಇಲ್ಲ ಬರೀ ನೋಟಿಸ್
ಇಲ್ಲ ನೋಟಿಸ್ ಆಗಿ 50% I will deposit madam. 43
42 ತಾನೆ the admits is subject deposit entire amount
43 my lord.
ಎಲ್ಲಾನು ಅಷ್ಟೇ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯಲ್ಲಿ ಪೇ ಸಬ್ಜೆಕ್ಟ್ ಡಿಪಾಸಿಟ್ ಎಂಟೈರ್ ಅಮೌಂಟ್.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್. 30 ಲಕ್ಷ. ಸೊ ಇದರಲ್ಲಿ ಬಿಫೋರ್ MACT ಆರ್ ದಿಸ್ ಕೋರ್ಟ್ ಮೈ ಲಾರ್ಡ್
50% ಇದೆ 49 ಐಎನ್ಎ ಇಲ್ಲ. Yes.
43, my lord. It is, I will deposit 50%, my lord. 36 lakhs is the award. I will deposit 50%, my lord.
ಇಲ್ಲ ಪೂರ್ತಿ ಅಮೌಂಟ್ ವೆಂಕಟೇಶ್ವರ
ಅಲ್ಲ 36 ಲಕ್ಷ ರೂಪಾಯಿ ಇದೆ ಅವಾರ್ಡ್. 15% ತಗೊಂಡೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ಗೆ. ಈ 36 years ಏಜ್, 56 years.
ಇಲ್ಲೇ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ, ಅವ್ರ ಅಪೀಲ್ ಹಾಕ್ಬೋದಲ್ವಾ?
ಅಲ್ಲ ಅದು 50% I will deposit and it may be released also. Yes, my lord.
ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಎಂಟರ್ ಅಮೌಂಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 2010 ನಟರಾಜ್.
The amount may be kept in FD, my lord.
ಹೌದು, ಆರ್ಡರ್ ಕಾಮನ್ ಆರ್ಡರ್ ಎಲ್ಲದ್ರಲ್ಲೂ ಎಲ್ಲ FD-ನೇ. ಬಿಫೋರ್ ದಿಸ್ ಕಾಲ್ ಅಂಡ್ ಡಿಪಾಸಿಟ್ ಫಿಕ್ಸ್ಡ್ ಡಿಪಾಸಿಟ್. ಏನ್ ಮಾಡ್ಬೇಕು? When? Well, I say or else in the alternative DC to be present. I'll grant you one adjournment. Next time, if it does not come, if the records don't come, he'll be personally present. Realist on the learned AGA to secure records by then. It is made clear that if the records are not secured by then, the deputy commissioner should be personally present. If you don't get the records, let him be here next Wednesday.
ಹೇಳಿ ಮ್ಯೂಟ್ ಮಾಡಿ ಅಂತಲ್ಲ ಮ್ಯೂಟ್ ಮಾಡಿ ಅಂತಲ್ಲ ಯಾವ್ಯಾವ ಮ್ಯೂಟ್ ಅಂತ ಮ್ಯೂಟ್ ಮಾಡುವ ಮ್ಯೂಟ್ ಅಂದ್ರೆ ಯಾವ್ದು ಯಾರು ತೋರ್ಸು ನನಗೆ ಆಯ್ತು ನಾನು ಆರಾಮ ಮಾತಾಡ್ತೀನಿ ಮ್ಯೂಟ್ ಮಾಡಿ ಅಂತ ಕೆಲಸದ ಅದು ಯಾವುದು ಅಂತ ಕೇಳಿದ್ನು ಈ ಕಡೆಯಿಂದ ಇಲ್ಲಿ ಇಲ್ಲ ಮುಟ್ಟದ್ ಬೇಡ ನನಗೆ ಅವತ್ತೇ ಕೇಳಿ ಅವರು ಅವತ್ತೇ ಕೇಳಬೇಕು ಹೇಳಿದ್ರೆ ಅವನು ಇವತ್ತು ಸುಮ್ಮನೆ ಹೇಳಿದ್ರು ಅದೇ
Court officer. Court officer.
ಏನೋ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಮೇಡಮ್.
Court officer ಬಂದಾರ ಇಲ್ರಿ?
ಇಲ್ಲಿ ಯಾರು ಅದೇನೋ ಈ ಕಡೆ ತೋರಿಸ್ತಾ ಇದೆಯಲ್ರಿ, ಏನು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
ಕೋರ್ಟ್ ಮ್ಯೂಟ್ ಇದೆ ಮೇಡಮ್.
Okay.
No, no.
do you want to implement? That main matter is not served. Sakangaren, but I will hold notice. One error. This is called El Paso. What do we do, Mr. Secretary? What do we do? What do we do about this problem? This could probably be applicable prospectively. But what about the applications which are filed earlier? The Mangalore matter. Mangalore matter. What is his total entitlement under that application of risk? ಅವ್ರ ಅರ್ಜಿಯಲ್ಲಿ ಎಷ್ಟು ಕೇಳಿದ್ರು ಅವ್ರು ಅದ್ರದ್ದು ಏನ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ 86 ಸೆನ್ಸ್ ಮುಗಿಸ್ಕೊಂಡ್ಬಿಡ್ಬೇಕು ಅದನ್ನ ಹೆಂಗೆ What is the solution? Because if there is a rule on the basis of which they have joined the services, after they come out, if you are going to tell them that we can't give you land, it is this policy I have my doubts because first of all it is prospective. and you talk about an existing housing scheme. So, the word you use in the rule is shall be allotted in his or her native taluk, and if not available in the native taluk, then in any other taluk of the concerned district at free of cost under any existing housing scheme of the state government or a special scheme. So you can include them in Ashaya scheme also then. But as against entitlement of 5 acres or so, then pay them the money, let them buy it from the open market. You set a particular rate, you offer that, you pay the money directly to the owners. This amendment would stand the scrutiny of law because the fundamental rule says that they're entitled for grant of land. Now you are going to turn it around and say, I will grant you only a site. Fundamentally, no, but because of this particular entitlement, most of them are inspired to join the army because when they come back, they will get some assurance. Now, if you're going to renege on that promise, no, you can delete the rule itself. Because my experience is nobody has a list of lands available. I don't recall of any list being prepared every year as according to the rules, notifying the lands available or non-availability of lands. Nothing is followed. So as and when sporadically somebody makes a fuss and cry, some land is given. So this gives a lot of discretion and lot of heartburn for these people saying that land is available there. Deputy Commissioner is not available there. How do we resolve this issue? Why can't this be uploaded on the web so that everybody knows every year what is land available, not available? Because in that, they would never make an application at all if the land is not available. And whenever somebody makes an application, some people are given, some people are not given. In every region. Because if you see the rule, it gives them an absolute right to get a property. What is the total amount of applications pending according to you for this ex-serviceman quota? And how much land would be required to meet this demand of 3,000? And do we have any statistics as to how much land is available in which district or which taluka where you can find this 15,000 acres? Because an argument was advanced. If you can acquire land for formation of an industry area for everything, why can't you acquire land for granting it to the ex-servicemen? No, suppose the people are prepared to pay you certain money. Suppose the standard rate fixes 10 lakhs per acre. Anything above, let them pay about 10 lakhs per acre and purchase. You only pay 10 lakhs to the purchaser directly. Don't involve the ex-serviceman. You set a standard rate. That is all that you can afford to give. Remaining they will pay and purchase. That is one of the options that they can consider. And this housing scheme, special housing scheme, this is a bit vague and again given to a lot of interpretations. Just to satisfy a demand, if an Ashraya site is granted, the very purpose of this rule is defeated. Can you put it on paper as to what is the scheme that you will formulate? I was more thinking in the lines of allotting, earmarking a bulk allotment on the urban development authorities and giving them, if you have 3,000 applications, you fundamentally require 3,000 sites. And if you offer those 3,000 developed sites in good areas, then maybe this demand will come down dramatically. This is very vague, saying that we will give in a scheme. I was told in Belgaum is the highest application that was. So at least if you can form, if you can talk to the Belgaum Development Authority and consider the possibility of allotting a special layout or whatever for these people, that will also have some considerable value, commercial value. Therefore, they may be satisfied, and this issue can be resolved. Or else we are forced to implement that rule as it stands. And I can't ask you to do the impossible by giving land which is not available. So some. No, but at least if you notify the lands which are available according to you, they'll be able to verify whether there's occupation or not. The moment you notify, they'll again be unauthorized occupation only after you notify. All of them is done with the collusion of the officials only. This occupation, most of the time, is with the connivance and knowledge of the officials. Or else it won't be that easy for people to go and occupy land. No, this is a practical reality, isn't it? It can't. And they allow it to happen, and therefore, if you look at it from a different point of view, a wrongdoer is being protected, and a person who has served the nation is being discriminated against. That dichotomy, I'm unable to. No, I understand. We also have sympathy to them, but it can't be at the cost of these people. You are non-suiting them because of protecting wrongdoers. In essence, it's unauthorized occupation. Because of various factors you have regularized, that's all. But it can't be at. I would suggest that you either compensate them in cash, come out with a scheme where you will pay a minimum sum of money, depending on the guideline value there, and they will pay the remaining. So then also they will not be able to abuse the system. And you can retain control of the entire transaction by paying the money directly to the purchaser. So the owners will shift completely from you to them. They'll have to find a land. They'll have to pay the balance. If you give it for free of cost, they will obviously enjoy. I can. They will use it as an opportunity to dispose it up and make money. The rules provide for taking action. If you don't take action, that can't be a ground to. Because there's a standing order of this court passed in Justice Raimalva, and nothing has happened in that. Elaborate guidelines were directions issued. None of them are completed. We are therefore forced to secure your presence. I get no pleasure in asking you to come and stand. No. I also understand that you will be busy. Getting you here is for to convey a sense of urgency about this. And I had this bunch of matters right from Dharwad. Everywhere the same problem. The only thing is the matter will be adjourned for sure. Apart from that, no positive outcome is forthcoming for either of the parties. They should know at least where they stand, whether they'll get land or not get land. You give me a date of your choice with concrete schemes. We'll put it across to them. Let us see what will come out. But I think you should treat it with some sense of urgency. It's been hanging fire for how many years? No, you, as I said, you take your time, but I want a definite resolution. It's up to you, but 3 months is a bit too long. The matter has been hanging fire now for how many years? No, that's all it. But the whole issue is again. Now that you're here, that case will be resolved in 2 weeks. We'll have it after 4 weeks. Make your attempt, then let us see what left. 8 weeks. I'll take your assurance that you will find a solution to this. I will not record anything. Gentleman's agreement is you will find a solution to this, which will be acceptable to everybody. The Principal Secretary Revenue is present pursuant to the order. He submits that he will check the instructions and make a positive statement regarding this next issue of grant of land to ex-service. Here is the matter. 28 September will be good enough. 28. By that time, please notify the list of available lands, because most of the dispute is that lands are available and the authorities are not accepting it. In Dharwad, most of the cases are to that effect. Affidavits are filed, counter affidavits are filed. So if there is this, that is the 1.3 alva. 1.3 alva. 1.3, still number 1.3 tane. 86 cents. This, shall I record that with this is done in 2 weeks? Or shall I? 1.3, the Secretary Revenue is present. Issues the report that the 86 cents that would be granted, the formality of granting 86 cents would be concluded within a period of 2 weeks. One matra relist on 2 weeks. 0.3 matra. Yes, 1.1. For that 1.3, that 86 cents. That is after 2 weeks. You don't have come on that date. You file a memo, that's good enough. 1.1.
My lord, I appear, your lordship.
What is this?
My lord, it is for corrections to be made, your lordship, in the writ petition.
What is the correction?
My lord, I am sorry, there was a mistake on my part that the respondent number 2 in my writ petition at page number 4 is shown as the Deputy Director of Public Instructions, your lordship, which has to be shown as the Deputy Director.
Respondent number?
Respondent number 2, your lordship. At page number 4. Which is wrongly shown as the Deputy Director of Public Instructions, which has to be shown as the Deputy Director.
1 minute. In the preamble of the order.
Please.
Date of the order is stated as 25/8/2021 instead of 25/8/2012.
Well, yes.
The same date is also found at paragraph 3. The council submits that this is an inadvertent mistake, and the date should actually read as 25/8/2012, accepting the said submission. The date referred to as 25/8/2021 in the order shall be replaced as 25/8/2012. The prayer is also made that the designation of the second respondent was wrongly made as the Deputy Director of Public Instructions. It ought to be Deputy Director of Public Instructions to the Deputy Director. Is that the correct one?
My lord, it had to be the Deputy Director, Your Lordship, of Department of Pre-University Education.
Read your application.
My lord.
It says to be changed from the Deputy Director of Public Instruction to the Deputy Director. That's all.
Please, Your Lordship.
You don't need the public instructions.
No, Your Lordship.
So the period of public instructions for the Deputy Director. Application is accordingly.
Obliged, Your
Milords, last time, Milords, there was a settlement, Milords.
What happened?
Milords, no, Milords, Milords, since Milords, construction building, Milords, under real estate sale deed, Milords, the settlement is not possible. I'm sorry, Milords.
What is the order in June?
Milords, order 13 and rule and 1 and 2 is allowed, Milords. Milords, Milords, I'm for the defendant number 9, Milords, the purchaser of the property, Milords.
They're the sisters of plaintiff, defendant 1 to 8, my lords.
You have challenged this grant of injunction?
Yes, Milords.
What is wrong with the order?
Milords, in this case, Milords, I have a purchase from a real estate sale deed, Milords. Earlier round of occasion, Milords, the earlier who were claiming to be a leasehold rights, Milords, had preferred an appeal, a writ petition, Milords, where a lordship came the matter before a lordships, Milords. In that matter, Milords, your lordships have settled the matter in WP number 102/000 of 2021, Milords, where they were claiming as a leasehold rights, Milords, and the matter was settled. And Milords, now subsequently one suit is filed again for the same, in the same respect of same suit property, Milords. Now, Milords, building is at one floor, Milords. Till then, Milords, they have kept quiet, Milords. After finishing of the building, Milords, now the application is filed and the application is allowed, Milords.
Maintain the status quo. If you want to settle it, maintain the status quo. Yes.
My lord, the intention was, if we are ready to purchase back the property at inflated rate, my lord permitted us to purchase the property, my lord. And yes, my lord. But they have not disputed our relationship in the lower court as well as the Honorable High Court before Honorable High Court, my lord.
We will confirm the order, that is all.
Yes, my lord.
Milords, only one submission, Milords. Still trial proceedings are going, Milords. Status quo be granted, Milords. That is only submission, Milords.
We'll simply confirm this order, no status quo. Order. If you will not put up construction, you will not put up construction.
Only status quo, Milords. Only that submission, Milords. Because earlier, sale deed ಮಾಡಿದರೆ ಆಮೇಲೆ compromise 27 lakhs paid, Milords, by it was settled earlier, Milords.
That's why I gave you a chance to settle.
No, Milords. Only I'm requesting status quo, Milords. Hangide hange irli am kattala till the disposal of the suit, Milords. Only that much. Only I'm requesting.
Challenging the grant of an injunction, whereby the ninth defendant is restrained from putting up further structure. The suit should be property for the disposal of the appeal. The trial court has noticed that the ninth defendant has purchased the suit should be property from defendant number 6 to 8. And suit was for partition, alva?
Partition, Milords. Suit for partition, Milords. Please.
Partition, separate possession.
One for partition, it would cause irreparable injury to the plaintiffs if the ninth defendant is permitted to construct the building and thereby alter the nature of the suit property. The trial court has observed that if the construction is to be permitted, there would be severe difficulties raising at the time of revision of the plaintiff in the suit to be decreed. The reasoning of the trial court is just and proper and does not call for any interference. Appeal is therefore dismissed.
Obliged, my lord.
Obliged, Milords.
Serial number 1.1.
Sorry, my lords, it couldn't settle, my lords.
1.1 minutes. Plus 1.3 alva. 1.1 minutes kindly called along with another connected matter.
ಯಾವ್ದು?
So Dharwad, my matter pertains to Dharwad bench only, minutes. WP FR number 1026220 of 22.
ನಂಬರ್ ಮಾಡಿಸಿ ನೀವು ಸೆಪ್ಟೆಂಬರ್ ಬರೋದು ಫಸ್ಟ್ ನಂಬರ್ ಮಾಡಿಸಿ ನಂಬರ್ ಮಾಡಿಸಿ ಮತ್ತೆ
Number 1, pass over matter. Number 35.
ಪ್ರದೀಪ್ ನೋಡಿದ್ರ What is second? 2014 ಇವಾಗಲ liability idea or he was placed expert in the court below. Should notice to R1. Time ತಗೊಂಡ್ರು ಕೊಟ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಅವ್ರಿಗೆ पैसा was disposed of on 11/6/2014. Director, the participants consider the petitioner's representation in accordance with law. This order was recalled in the petition filed by Vaiti Narendra Babu, representative Union by 2016. Already spoken in as on the date of filing of the petition, and since she was not made a party, the petition could not have been allowed. As narrated in the said order, since revenue records stood in the name of Marodamma as on the date of filing of this writ petition, the prayer made in this writ petition to consider the representation for entering his name cannot be granted. As a consequence, this writ petition is dismissed. This appeal is filed by the insurer principally on the ground that the driver of the offending vehicle did not possess the necessary endorsement to drive a transport vehicle, and therefore it could not be made liable for the compensation. In the light of the judgment rendered by the apex court in Chamanana, in Pappu Yadav's case, the said argument never sustained. The only remedy available to the insurer would be to satisfy the award and thereafter proceed to recover the compensation from the owner of the vehicle. Accordingly, the impugned award of the tribunal is modified only insofar as it relates to casting the liability only on the insurer. It is made clear that the insurer shall satisfy the compensation award with the tribunal and thereafter be entitled to initiate proceedings for recovery against the owner of the vehicle. To the above modification, the appeal is dismissed. The amount and deposit transfer ಆಗೋಗಿದೆಯಾ? The name of Sri Lakshmi Solla Bidili. These appeal. In awaiting decision of apex court. Ravi Shankar. ಮೊನ್ನೆ ಇತ್ತಲ್ಲ, ಮೊನ್ನೆ ಬಂದಿತ್ತಲ್ಲ ಅದೇನ ಇದು? ರವಿಶಂಕರ್. ಲೋಡ್ ಅಂತ ಇದೆ, ಲೋಡ್ ಅಂತ ಇದೆ ಕಾಂಪಿಟೇಷನ್. $1472. No? What are the facts in 1472? The liability is fastened against the owner of the insurer of the lorry. ಮಾಡಿದಾರ ಆ ಕೇಸಲ್ಲಿ 166 ಅಲ್ಲಿ our claim petition made liable against you. You are supposed to pay their compensation. Your vehicle had an act. Your vehicle had an insurance policy. Act only. Statutory policy. Therefore, you. Section 163, the right to the instead of clearing applications are ready. But then along with that one, I had that because therefore, there will be a contradiction in one set of claim petitions. You are held responsible for the accident, and no appeal is preferred against that. Not saying that it is not maintainable, but if your argument is accepted, in the same accident, you are made liable for the consequence of the accident, and in your claim petition, somebody else is being made liable. That is not the case. That is. I would not go the negligence. And even the reasons also the same effect. But the problem is you're accepting the finding in the other that you are responsible for the accident. The liability is fastened on you. You could have filed an appeal against it and sought for impleading them. The matter could have been solved. We know the settled position, Mr. Bhatt, but this is a case in which the finding is recorded, which is accepted by you, that you were the person responsible and liable for the consequences of. So if you had challenged that order, it would have been easy for me. I would have simply set aside that finding and made that insurance company liable and also allowed your claim petition. You are accepting the fact that the liability arising out of the use of the motor vehicle is upon you in respect of the occupants of this particular vehicle. But now you want to fasten the liability on the ground that negligence is a question that you can't. If I grant your claim petition, I will also pass an order directing that the money be paid to them because you are not satisfied their award. Then I'll ask the insurance company to take that money. If you are responsible for the accident, there must be a consequence. Yeddu sotanga abudatawa. Ravi Shankar. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ನೋಡಿ ಬರ್ಲಿರಿ ಹೇಳಿದನಲ್ಲ. ಏನಾಯ್ತು? Lorry. When they rose at the petition again, was now on the 160 day we are not they are only concerned with the use of the 160 we had a permanent
So your liability you're admitting now. What is the injury suffered?
Dislocation of hip, injury over back of the injury over left. These are the injuries that is noted on. There is no critical evidence. The trial court does not quantify. There is no quantification. Not sufficient mother. This schedule or maybe interpreted insufficient as well.
Was there any evidence indicated here about the disablement? Evidence?
Quantification. But in the event that there is no disablement, in the event, you not place that.
$63.
Schedule, second schedule. Second schedule. Nothing is sufficient.
Second schedule ಅಲ್ಲ. ಎಲ್ಲಿ ಓದ್ತಿದ್ರ 5C. This is after amendment. After amendment. What was the earlier? What is the injury that you claimed that you suffered? Batra.
What is your evidence regarding disablement? Read it. Please read it. %10 functional disability until. Okay. What is the salary that you claim? What is the salary that you claim? And how old were you? Age.
7 years at the time of
ಎಷ್ಟು multiplier? %10 of 3,000. In Prakara, I'll accept this 10%. So sending it back only. This appeal is filed by the claimant being agreed with the dismissal of his claim petition. The claim petition that was filed under section 163 capital A of the MV Act was dismissed on the ground that in the companion claim petitions filed by the other claimants, it had been held that the accident had occurred due to the negligence on the part of the claimant herein. In a proceeding under section 163 capital A, the question of negligence is not germane to the consideration of the claim if the accident and permanent disablement is established. So, compensation as enumerated in the second schedule will have to be paid. In the instant case, the accident has been established, and the learned counsel for the petitioner claimant submits that as per exhibit P3, the permanent disablement to the extent of 10% has been certified by AG Hospital and Research Center. In light of the fact that there is a permanent disablement as per the doctor's certificate, it would be an appropriate case to allow the claim petition and award compensation of 300 into 12 into 17. Viren Barala alva? Medical expenses then other limit is alva. The claimant will also be entitled to medical expenses of esto? Actual expenses, not ಎಷ್ಟು ಬಿಲ್ ಎಷ್ಟಿದೆ? ಬಿಲ್ ಎಷ್ಟಿದೆ? Also be entitled to medical expenses of rupees 15,000 as stipulated in the second schedule, clause 4, subclause 2 of the second schedule. Such sum should carry an interest of 6% per annum from the date of the claim petition, date of disposal. Only 163 is In facts, ನೀವೇ ಡ್ರೈವ್ ಮಾಡ್ತಿದ್ದೀರಾ? You are the owner come driver. Who's the owner? I've already taken the view that it does not matter whether I've held that the relationship does not matter. I've said it therefore follows that whether the owner was driving the vehicle or whether the vehicle was borrowed and was being driven by any other person, or whether the accident occurred due to a wrongful act of the raider, or whether the raider can take advantage of his wrong, all become immaterial in a proceeding under section 163 capital A.
The permission of the owner of the vehicle.
That is what I have held. Yes. But the finding that that was the facts. That was the facts of that case. But after consideration of the entire chapter, I have held that it makes no difference who was driving the vehicle. I have held that so long as there's an accident and death is established, the insurer will have to pay.
This was the third point. Who is the third party that will discuss it? It was one correct.
I have held in this, but
In this case, this is what the third party.
I'm not on that. Under 163 capital A, I have held or held it. I have held that under 163A, which is a special provision, the limitations under 147 or 149 cannot be imported. This is a standalone provision. Whenever these two things are established, you will have to pay compensation. I will have to follow my own decision. I can't disobey my own decision, isn't it? The non-citation and against the work agalega. That is why I said this is under section 147 and 149. I have said 147, 149 ಗೆ third party ಎಲ್ಲ ಬರುತ್ತೆ. 163A ಗೆ that is irrelevant for 163 capital A.
For 163 capital A, it does not matter as to who is the driver. Please read para 53 of my judgment first. I have considered the scope of 163 capital A with reference to this third party. The facts are not relevant there. The position that question will not arise according to para 53 is what I'm trying to tell you. La.
Insurance product that has been answered. I will get legal. Second part. The second part. The third party has not been declared exclusive in the act. Section 145D usually definition and simply says that third party leads to government. That does not cover potential difficulty in understanding who we and import of sector. The term third party must necessarily refer to party other than those who are parties to the contract of insurance. For contract of insurance, insurance party will involve more than other parties. Any person other than the party or party would necessarily refer to the third party. Then how the insurance third party appears in top of level that guidance. Considerable support for them is available from any third party is without insurance. Third party in the following.
Literally, even this judgment could be against you. The person who was driving the vehicle was neither a party to the contract of insurance. Was he a party to the contract of insurance? So the driver of the vehicle. No. According to this division bench ruling. Chandrakant.
Section 141 does not require for the death of bodily injury to owner of the vehicle. Policy does not go against for injury to owner himself. The insurance is labor for injury to vehicle accident. Right, most injury for owner vehicle, not for injury to owner. You the owner, you does not have that. Then other decision NPJ 2008 is owner of the owner issue. That's all the time application. Maintenance paper. Owner and another person was ready to use it. And more evidence was very good. Motorcycle rate also you do that very extra. Even the principles of the disease will drive and under section 160 of the chapter of ordinance maintained. Now, where borrow vehicle, separately use of the owner of the vehicle, when owner of the vehicle enter this is the borrow transfer for insurance the India for in that case, is the third part.
I will consider.
Is not third part.
I will consider. This appeal is preferred against the judgment against the dismissal of the claim petition, which had been filed under 163. Dismiss agita allow agita. ನೀವು ಕ್ವಾಂಟಮ್ ಅಲ್ಲಿ ಬಂದಿದ್ದೀರಾ MFA 1292/2010 is preferred by the insurer challenging the award of rupees 3,68,500, while MFA 417/2010 is filed by the claimant seeking for enhancement. The claimant filed an application under section 163 capital A contending or that Rahul, the brother and brother of the first claimant and the son of claimants 2 and 3. The brother of while contending that Rahul, the son of claimants 1 and 2, and the brother of the third claimant, was riding a motorcycle which was owned by the first respondent, and while so riding the motorcycle, he lost control of the motorcycle and met with an accident which resulted in grievous injuries to which he ultimately succumbed. The tribunal, after considering the evidence, has proceeded to determine that the claimant was entitled to a compensation of 3,68,500. Learned counsel for the insurer contends that Rahul had, by borrowing the motorcycle from the first respondent, had stepped into the shoes of the owner and therefore could not maintain the claim under section 163 capital A. He sought to place reliance on the judgment of the apex court rendered in the case of Oriental Insurance was originally rendered in case of Dhanraj versus New India Assurance, Kaila 2005, Karnataka 1217, case of Oriental Insurance versus Rajni Devi 2008, ACJ 1441, and the division bench ruling of this court, the case of Dr. S. Jairam Shetty versus National Insurance Company, Kaila 2002, Karnataka 3117. In the case of Whittle, the undersigned in MFA 22199/2012 has already held as follows. Para 59 to 62. In the light of this judgment, the contention of the insurer that Rahul, by being the borrower of the vehicle, was not entitled for compensation cannot be accepted as held in the said decision. The question as to who was riding the vehicle or in what manner the victim was related to the owner is completely irrelevant in a proceeding under section 163 capital A. However, Learned Counsel for the claimant sought to place reliance on the decision of Dhanraj. In the said case, the Supreme Court was considering the import of section 147 as noticed in the aforementioned decision. I have already held that the provisions of section 147 or 149 cannot be incorporated in a claim under section 163 capital A, and section 163 capital A is a special standalone provision, and so long as the twin requirement of establishing an accident and death of permanent disablement is proved, the consequence of payment of compensation is inevitable. Similarly, the reliance placed on the decision of the Supreme Court in Rajin Devi's case would also not be applicable, since in that case held that the owner of the vehicle cannot also be the claimant. As stated above, the rider of the motorcycle was not the owner, and therefore this decision can have no application. The decision, the reliance placed on the division bench ruling of this court in Jairam Shetty's case can also be of no avail to the petitioner. In fact, in the said decision, it has been held by the division bench that the term third is held as follows. The reading of the said extract would indicate that any person other than the owner who entered into the contract of insurance and the insurance company would be a third party. Admittedly, the rider of the motorcycle, that is Rahul, was not a party to the contract of insurance, and therefore, even according to the decision of the division bench, he will have to be held as a third party. Consequently, I find no reason to entertain the appeal of the insurance company, and the same is dismissed insofar as the question of liability is concerned. Quantum ena? $3,000 ಎಷ್ಟು ವಯಸ್ಸು ಎಷ್ಟು? ಮಲ್ಟಿಪ್ಲೇಯರ್ ಎಷ್ಟು? ಇದನ್ನ ಇಗ್ನೋರ್ ಮಾಡ್ಬೋದಾ? ಸೆಕೆಂಡ್ ಶೆಡ್ಯೂಲ್ ಬಟ್ ಅವರು ಸರಳವರಂ ಕೇಸಲ್ಲಿ ಅಮೆಂಡ್ ಆಗಿದೆಯಾ? ಕೊಡಿ ಸರಳವರ್ಮ ಕೇಸ್. $6,84,000 minus 4,58,280. ಸರಳವರ್ಮ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್? ಐದು 163A ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ 166 ಕಾ? ಅಲ್ಲ, ಅದನ್ನ ಫಾಲೋ ಮಾಡ್ಕೊಳ್ತಿದ್ರು. ಅದನ್ನ ಕೆಲವರು ಕೋರ್ಟ್ಗಳು 163 ಮಾಡ್ತಾರೆ, ಕೆಲವರು ಬೇರೆ ಮಾಡ್ತಾರೆ. ಆದ್ರಿಂದ ನಾವ್ ಹಿಂಗ್ ಹೇಳ್ತಿದೀವಿ. ಇದು 166 ಅಲ್ಲಿ ಹೇಳಿರೋದು, 163 ಮಾಡಿಫೈ ಮಾಡಿದಾರ. As far as the claim for compensation is concerned, the claimant contended ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇವರು? ಅಲ್ಲ, though the tribunal has taken the income at ₹3,000, the tribunal has ultimately awarded a sum of ₹3,64,000. Or as per the second schedule, in respect of a victim whose age does not exceed 20 years, a multiplier of 16 is to be adopted, and a sum of ₹6,84,000 is to be granted. And out of the said sum, 1/3 would have to be deducted towards his personal expenditure, and the amount payable to the claimant should be a sum of ₹4,58,280. The finding of the tribunal, therefore, holding that a sum of ₹3,64,000 is to be granted, will have to be modified, and it will have to be held that the claimants are entitled to a sum of ₹4,58,280. In addition, the claimants will also be entitled to. Though we can award a larger sum, like 88. But this Supreme Court has said the schedule is outdated. You have to modify this. ಹೇಳಿದ್ರೆ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ₹30,000 ಮಾಡಿದ್ದಾರೆ. Should be entitled to a sum of ₹24,000 each towards loss of consortium and ₹33,000 under the conventional acts. as held by the Supreme Court in Pranay Sethi's case. The amount of general damages awarded stipulated in the second schedule would not be applicable, having regard to the fact that the amounts mentioned therein are of the year 1988, and the Supreme Court itself, in various decisions, has held that the notional income indicated in the second schedule cannot be applied blindly, and an enhanced amount would have to be applied. In the light of the decision of the Constitutional Bench, holding that the consortium payable is rupees 44,000 per claimant, the above sum is being awarded. This is being allowed in part payment.
Second response.
Duly argued. ಏನ್ ರಾಜಶೇಖರ್ ಅವರ ಕೇಸ್ ಇದು
163A.
ಏನಾಗಿದೆ?
ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ, ಸೆಲ್ಫ್ ಆಕ್ಸಿಡೆಂಟ್.
ಅವನೇ ಓನರ್ ಅಲ್ವಾ?
He was not the owner.
Pay and recover ಅಷ್ಟೇ.
Para 11 of the judgment, your lords. Para 11. Additional issue.
Pay and recover ಅಲ್ವಾ?
ಹೌದು.
Dismissal of the claim petition. The claimants filed a claim petition under section 163 capital A, contending that ಶಿವಾನಂದ ಏನಾಗಬೇಕು? ಶಿವಾನಂದ ಅವ್ರಿಗೆ
parents and sister petitioners.
Shivananda, the son of claimants 1 and 2, and the brother of the third claimant, met with an accident while he was riding a motorcycle and lost control and collided with Moodlekatte circle, as a result of which he sustained grievous injuries and ultimately succumbed to the same. The tribunal has come to the conclusion that Shivananda did not possess a driving license, and therefore the claim petition could not be entertained. And it accordingly proceeded to dismiss the claim petition. In a proceeding under section 163 capital A, the only requirement of the claimant is to establish that there was an accident arising out of the use of the motorcycle, which has resulted in a death or permanent disability. And if these two requirements are attracted, the liability imposed under section 163 capital A, which is titled as a special provision, cannot be avoided. Consequently, the award of the tribunal dismissing the claim petition cannot be sustained and is accordingly set aside. It is recorded by the tribunal that the deceased was having an annual income of rupees 39,000. Having regard to the age of the deceased, ಎಷ್ಟು ವಯಸ್ಸು?
30 years.
That to the fact that the claimant was aged 30 years, as per the second schedule, you would be entitled to a sum of rupees.
Yeah. Yeah.
5,76,000.
ಅಲ್ಲ ಟೋಟಲ್ 4,49,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಅಮೌಂಟ್ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ ಅದು?
ಅದು ಕರೆಕ್ಟ್ ಇದೆ. ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮೆಡಿಕಲ್.
Sum of rupees 4,49,600. 4,42,000 towards
49.
Towards loss of dependency, and a sum of rupees 3,103 towards medical expenses, comma. In addition, the claimants being the parents and sister of the deceased, each of them will entitled to a sum of rupees 44,000 towards loss of consortium, and a further sum of rupees 33,000 under the convention acts as held by the constitutional bench of the Supreme Court in this case. The insurance company shall satisfy the said award amount and thereafter be entitled to proceed against the owner of the vehicle and recover the compensation that it has paid to the claimants. Bill is accordingly made. Who's opposing? Yaar lawyer yaar. You are for? You are the owner.
Passing the liability of the owner on the fact that no number of traveling, that was 12 plus 1 and 12 plus 1 was not completed, but on that ground only the land and relying upon the judgment of like that, the law showed that number of people traveling the vehicle is not not possible that the paragraph of the surrender.
What is the vehicle here? Who's was the insurance company you said?
I appear for insurance company in one matter, 7136.
ಎರಡು ಒಂದೇ ಆಕ್ಸಿಡೆಂಟ್ ಬೇರೆ ಬೇರೆ ಆಕ್ಸಿಡೆಂಟ್?
Same accident.
ಬೇರೆ ಬೇರೆ ಅಂತಾರೆ ಅವ್ರು ಒಂದೇ ಅಂತಾರೆ.
One is 12 plus 1. That was completed. Second one was 13 plus 1. But then there were 18 plus 1 members. There is separate. Well, sorry, I don't know that. About 20 minutes kind of relevant This claim of the terms of the policy that influence should make up the entire clarity for including the driver. Because it's for when traveling in the vehicle, not having this to the point of view of the influence of the occurring of accident. How could those added contributed to the causing of it? Causing of it is keeping apart the load it was carried. It is no case the driver of influence takes the responsibility for the accident. In fact, one distributed what is provided error against the insured vehicle resulted in the damage. Here, by lifting a person or even see by the driver or the cleaner of the vehicle without the knowledge of the owner cannot be such a fundamental belief that the owner should all events be denied.
In pay and recover Srinivara?
ಹೌದು ಮಾಡ್ಬೋದು.
Pay as already paid, already deposited the people also family
ಎಷ್ಟು ಪೂರ್ತಿ ಅಮೌಂಟ್? This was 2,08,000. Case of injury or
ಕನೆಕ್ಟೆಡ್ ಡೆತ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ 75,000.
they have not prepared any appeal.
No, not filed.
A full bench ಯಾವ್ದು ಡಿಸಿಷನ್ ಪೇ ಅಂಡ್ ರಿಕವರ್
ಎಲ್ಲವ
ಎಲ್ಲವ
ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ವರ್ಸಸ್ ಎಲ್ಲವ.
ಸಿಟೇಷನ್ ನಿಮ್ಮ ಹತ್ರ
ಸೈಟೇಷನ್ ಕಾಣ್ತಾ ಇಲ್ಲ. ಐ ಥಿಂಕ್ ಜಡ್ಜ್ಮೆಂಟ್ ಡೇಟೆಡ್ 12/5/2020 ಅಂತ ಇಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ದೀನಿ.
ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ, because if I have to ask them to make the payment.
Both the owner and driver, they represented old written statement.
About 25,000 deposit. I also filed a memo. Model 2725.
ಡಿಪಾಸಿಟ್ ಮಾಡಿದೀರಾ? 25,000 ಮಾಡಿದ್ರೆ ಮಿಕ್ಕಿದ್ದು the order was keeping open the question of limitation and pending consideration of the stay application on merits. Stay for the operation of the impute judgment and award is granted with the condition that the appellant shall deposit the entire award amount with up-to-date interest before the tribunal.
That is very well, not happening. Very well.
In the first case, I'll continue. Second case, 71,000 ಹಾಕಿದೆ.
ಅಲ್ಲಿ 75,000.
ಇಲ್ಲಿದೆ. That is in the connected appeal, not in this MFA. The first appeal is MFA 11407. In that, if I have to pass an order, I have to say what is the amount that you deposit. These two appeals are filed by the owner of the vehicle, challenging the award of the tribunal so far as it passes the liability on the owner. It is contended that the tribunal has foisted liability on the owner on the ground that there was a breach of the permit conditions in as much as the vehicle was found to be carrying passengers in excess of the prescribed capacity. In view of the decision of this court in Yellava's case, the event of a breach of a policy condition, the insurer is liable to satisfy the compensation and thereafter recover the same from the owner. 25,000 ರೂಪಾಯಿ ಇಲ್ಲೇ ರಿಕವರಿ ಮಾಡ್ಬಿಡ್ತಾರ ಅವರು.
ಹೌದು, ಇದನ್ನ
22,000 ಆಮೇಲೆ 66,000 ಇಲ್ಲ ರಿಕವರಿ ಆಗುತ್ತೆ. In that view of the matter, the insurance company is directed to satisfy the compensation and thereafter recover the sum from the appellant owner herein. The insurance company will be entitled to ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಇನ್ನೇನು ರಿಕವರ್ ಮಾಡೋದು. You already paid ಅಲ್ವಾ? The insurer will be liable to pay the sum balance that is payable to the claimants, and it would not be necessary to pay the sums that have already been paid by the owner to the claimants in these appeals.
Yes.
The appeals accordingly allowed to the extent stated above.
Yes. Amount in deposit be transferred to the tribunal for disbursement.
ಅವರಾಗಲೇ ತಗೊಂಡ್ಬಿಟ್ಟಿದಾರಲ್ಲ.
ಸರ್ ತಗೊಂಡಿಲ್ದೆ ಹೋದ್ರೆ
ಡಿಪಾಸಿಟ್
ಇಲ್ದೆ ಹೋದ್ರೆ ಅದನ್ನ ಅಬ್ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ರೆ
pay and recover ಅಂದ್ರೆ pay and recover from you only.
ಹೌದು.
How? You are only saving that amount that you have paid. That's all they can. Amount in deposit, the same should be handed over to the insurer.
Sir, amount in deposit pay.
If there's any amount in deposit, it will be paid to you.
To the insurance company.
ನೀವೇ ತಾನೇ ಕೊಡ್ಬೇಕಿರೋದನ್ನ.
ಸರಿ.
ಎಸ್. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಏನ್ ಇಂಜುರಿ ಏನು? ವಯಸ್ಸು ಎಷ್ಟು? ಡಾಕ್ಟರ್ ಏನ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದು? ಇಲ್ಲ ಬಟ್ ವೇಜಸ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಸ್ಯಾಲರಿ ಆಮೇಲೆ loss of amenities, pain and suffering. The pain and suffering, loss of amenities. ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಹೇಳಿ? ಆಮೇಲೆ ಅಮ್ಯುನಿಟೀಸ್ ಎಷ್ಟು ಬೇಕು ಹೇಳಿ ಕರೆಕ್ಟ್ ಆಗಿ. ಅವ್ರು ಒಪ್ಕೊಳ್ತಾರೆ, ನೀವು ಹೇಳ್ಬೇಕಷ್ಟೇ. ಅವ್ರು 75,000, pain and suffering 75,000, loss of amenities 25,000 ಅದು. 75 plus 40 ಮಾಡ್ತೀನಿ. Pain and suffering 75, loss of amenities 40. The claimant is an appeal. Being dissatisfied with the compensation is 3,37,000. The tribunal, after assessing the evidence, has awarded the following sums. The tribunal has determined the monthly income of the claimant to be rupees 3,000. Since there was no documentary evidence, it has assessed the permanent disability at 25%. The assessment of permanent disability has not been questioned by the insurance company, and the same is just and proper and therefore accepted. Therefore affirmed. As far as the income is concerned, since there was no documentary evidence, it would be appropriate to adopt the monthly income determined by KSLSA, which for the year 2006 will be rupees 3,500. Consequently, towards loss of future income, the claimant would be entitled to the sum of rupees 3,500 into 12 to waste multiplier to 15 into 25%. Having regard to the fact that the claimant had suffered fracture of both the legs, the amount of rupees 50,000 awarded towards pain and suffering is required to be enhanced to rupees 75,000. Similarly, the sum of 10,000 awarded towards loss of amenities is required to be enhanced to rupees 40,000. The medical expenses awarded, being based on documentary evidence, is affirmed. Since the monthly income is taken as 3,500, the loss of income to the later period would be 4 months, 14,000. Like 14,000. 14,000. 14,000. Consequently, the claimant will be entitled to the following sums. Appeal is thus allowed and proper. Dashed against? Load the Why does it say so? Yes. The driver was not examined. Lorry driver was not examined. No, the allegation was against the lorry driver. Lorry driver has not stepped into the box. No, for the purpose of the tribunal, allegation is made against the driver that he was responsible. He was negligent. That is not denied. If it is not denied, not you, the driver should come and say, no, I was not negligent. He should be subject to cross-examination. Or else that remains unrebutted. You had no personal knowledge. Where is the finding rear wheel? And in contention, but where is the evidence? E-report is not evidence. IMA report idya? IMA report idya? Or not? The insurer has filed this appeal, challenging the award of rupees 2,79,000 on the ground that the accident occurred due to the negligence on the part of the rider of the motorcycle. And the finding recorded by the tribunal to the contrary is incorrect. The tribunal, on elaborate consideration of the evidence adduced before it, has come to the conclusion that there was adequate material to infer that the driver of the lorry was responsible. So it has taken note of the fact that the driver of the lorry did not choose to examine himself before the tribunal, and having regard to the fact that there was a collision between a larger vehicle and a two-wheeler, there is a presumption to be drawn that the negligence is on the part of the larger vehicle. In my view, the reasoning record with the tribunal is just and proper and does not call for any interference. The appeal is accordingly dismissed. The amount and deposit shall stand transferred to the tribunal. Mahesh avare. Mahesh.
Shiva Mahesh.
Argument ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸರ್.
I pay for the appellant, pay for a short accommodation.
ಏನಕ್ಕೆ ಕೊಟ್ರೆ?
This is a matter wherein the trial court has rejected my petition on the ground that there was two different statements. In the first statement made by the injured, once he said that he has fallen from the tree and the injury has caused. Now the subsequently, no such statement is there on the record, but the learned judge has rejected that it is a fraud played on the court and that it has been rejected. The entire complaint should, compensation claim is.
ನಿಮಿಷ ಮಹೇಶ್ ಅವರೇ ಆಯ್ತಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಮಾಡ್ತೀರಾ? ಮಹೇಶ್ ಅವರೇ,
I am in the other court, my lord.
Lord, shall I continue, Lord?
Yes.
Lord, the learned tribunal has rejected the claim is that this fraud is played on that on the court and false statement made. In the first instances, he has given a statement to the effect that he has fallen from the tree and injury is caused. Subsequently, a complaint was filed. It was the finding given by the learned judge. My lord, there are documents are produced. That's a complaint, is copy of the complaint, IMB report, and as well as spot measure, wound certificate, all this were produced. The learned judge has rejected only on the ground that some statements were made in the first instance that he has fallen from the tree. And the learned judge has given that it is a fraud played on that. But even the insurance company has not taken up such contention. The issues framed may kind of be seen. They have not taken up such contention. But subsequently, when they have given they have filed an application for amendment of their written objection statement, it was rejected. That has reached finality. Issues only, it's available at page number 12, my lord. Only in respect to two issues were framed. And regarding the making a false claim or fraud being played, no objections were raised. And yes, sustained severe injuries and has become a not in a position to move about also. Has got about 3 acres of dry land, 2 acres of agricultural land. All that things he is not in a position to cultivate also. My submission is a fit case to be remanded and for a fresh trial, my lord. My submission is this. Charge sheet is also filed as against the accused.
Plead guilty ಮಾಡ್ಕೊಂಡ್ರಾ?
Madam,
plead guilty ಮಾಡ್ಕೊಂಡ್ರಾ ಅವರು?
Plead guilty ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅಲ್ಲ, by that itself your lordship come to the conclusion that it is a false claim. The question itself.
Eight not nine. Extend date to Was this doctor examined? The doctor who made the center was he examined? What is his evidence? No. Was he examined? Was he examined before the court? PW? ಯಾವ witness ಅವರು? RW. RW3 ನಿಮ್ಮವರಲ್ಲ?
Also in the same way, whoever the team is rated that it was some false of the team, up to 20%. And it is a discharge between the case sheet of Gopal hospital, Memorial Hospital. And the team was summoned to be responding. This is marked by a clear charging. And on the basis of asking, the mentions that this is false of the they are summoned to court. The evidence has been ready. And 20 the documents, which are summary evidence is ready. Was considering Gopal hospital. And at the exam before the court also indicates that the history was given that is false of the history. Something false of the history.
Still, ಯಾವ ಸರ್ ತಗೊಂಡಿರೋಣ?
Yes. Satyavan Gopal hospital. Memorial hospital. They are summoned and The order has been examined.
In this exhibit B16, this is a summary sheet of the KR Hospital, Mysore. What? Doctor has said he made the entry on the basis of the statement given by the attendant. He does not know who the attendant is. The judgment relay, Amal Bardin judgment. First facts ನೋಡ್ಕೊಳ್ತೀನಿ ಆಮೇಲೆ ಜಜ್ಮೆಂಟ್ ಮಧ್ಯೆ ಬರ್ತೀನಿ. ಅದ್ರ ಪ್ರಕಾರ ಯಾರು ಹೇಳಿದ್ರು ಅದನ್ನ ಬರ್ಕೊಳಕ್ಕೆ ಅಂತ ಡಾಕ್ಟರ್ ಹೇಳಿಲ್ಲ. I will read the evidence for you. ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇಲ್ಲ ಅಲ್ವಾ? ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇಲ್ಲ ಅಲ್ವಾ ಎವಿಡೆನ್ಸ್? ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಗೊತ್ತಿನ ಕೇಳಿಸ್ಕೊಳ್ಳಿ. ನಾನು ಗೋಪಾಲ್ಗೌಡ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಇದು RW2 ಸುಮಾರು 20 ವರ್ಷಗಳಿಂದ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಇಶಾನೆ 6-2 ಕೇಸ್ ಶೀಟ್ ನಲ್ಲಿ ನನ್ನ ಬರವಣಿಗೆ ಇದೆ. ಗಾಯಾಳುಗಳನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡ ಬಂದು ಸೇರಿಸಿದ ವ್ಯಕ್ತಿ ಗಾಯಾಳು ಎತ್ತರದಿಂದ ಬಿದ್ದ ಬಗ್ಗೆ ಗಾಯಾಳು ಹಿನ್ನೆಲೆಯನ್ನು ಹೇಳಿದ ಆಧಾರದ ಮೇರೆಗೆ ನಾನು ಕೇಸ್ ಶೀಟ್ ನಲ್ಲಿ ನಮೂದು ಮಾಡಿದ್ದೇನೆ. So it is not the statement of the victim. Correct. Now there is this exhibit P16. This is the case sheet of the KR hospital. This is what the doctor says. Right, RW2 ಯಾರ ಕರ್ಕೊಂಬಂದವ್ರ ಹೆಸರು ಹೇಳಿದ್ರು ಅದನ್ನ ನಾನು ಬರ್ಕೊಂಡೆ ಅಂತ ಅಂತಾನೆ. ಆಯ್ತಾ? Exhibit P16 ಈ ತರ ಹೇಳ್ತಾರೆ. History of cell fall from a tree 12 PM on so and so at K Battalli. The patient has given history of loss of consciousness. Half an hour when he was awake, he could not move his leg. If he was unconscious, on what basis was the entry made that he fell from a tree? ಇಲ್ಲ, ನೀವೆಲ್ಲರೂ ಒಂದ್ ಕಡೆ ಅವನು ಹೇಳ್ದ ಇದ್ರನ್ನ ಅವನೇ ಬಿದ್ದ. ಅದ್ರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ history of cell fall and I am accepting your argument, but the problem is that entry is made on the basis of the statement of a person who brought him to the hospital. He has not been examined. ಇಲ್ಲ, ಯಾರು ಕರ್ಕೊಂಡ್ಬಂದು ಡಾಕ್ಟರ್ ಹೇಳಿದ್ರಲ್ಲ ಈ ತರ ಮೇಲ್ಗಡೆಯಿಂದ ಬಿದ್ದ ಅಂತ, ಅವನನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಡಾಕ್ಟರ್. therefore ಅವನ್ ಡಾಕ್ಟರ್ ಏನ್ ಬರ್ಕೊಂಡಿದ್ದ, ಯಾರೋ ಹೇಳಿದ್ರು ಬರ್ಕೊಂಡಿದ್ದಾನೆ. No, if this entry in the KR hospital is ಒಂದ್ ಕಡೆ ಹಿಸ್ಟ್ರಿ ಆಫ್ ಅಂತ ಬಂದ ಹಂಗೆ ಬಂದಿದೆ. ಅದಕ್ಕೆ ಕೋರ್ಟ್ ಕೇಳಿದಾಗ ಯಾರೋ ಬಂದ್ ಹೇಳಿದ್ರು ಅದನ್ನ ನಾನು ಬರ್ದೆ ಅಂತ ಹೇಳ್ತಾನೆ. ಈ ಕ್ಲೈಮೆಂಟ್ ಹೇಳ್ದ ಅಂತ ಎಲ್ಲೂ ಹೇಳಲ್ಲ. ಆಮೇಲೆ if the evidence indicates that he was not conscious and only after he woke up he realized, then whatever is said to the doctor would be of any consequence. Doctor, if he had paraplegia and if he was hospitalized for 45 days, the delay in filing the FIR is of no consequence. He was immobile. He had suffered paraplegia. So that delay aspect is not a very big criteria. But in the light of the fact that the doctor has said that he merely wrote whatever was told to him by an attender, can the court hold this fraud involved? And the driver does not dispute the accident. He has pleaded guilty. Then you have not established collusion. You have not proved that the driver of the auto was in some way related to this person and this was a got up case. You will have to establish that. It can't be presumed this collusion. Now, after 1 month ಅಂದ್ರೆ ಅವನು ಕೈಕಾಲು ಬಿದ್ದು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಇದ್ದಾಗ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗ್ತಾನೆ, ಅವನು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಕರೆಕ್ಟ್ ಆದಾಗ ಆ ಡಾಕ್ಟರ್ ನಿಮ್ ಕೈ ಕೊಟ್ಟಿದ್ದಾನೆ, ಅವ್ನು ಕರೆಕ್ಟ್ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ನು ಹೇಳ್ಬೇಕಿತ್ತು, ಇವನೇ ಬಂದು ಹೇಳಿದಾನ ಅಂದ್ರೆ ಹೇಳಿದ್ ನಾನು ಬರ್ಕೊಂಡೆ ಅಂತ. ಅವನ ಹತ್ರ ಹೇಳಿಲ್ಲ ಡಾಕ್ಟರ್. ಫಸ್ಟ್ ಡಾಕ್ಟರ್ ಬಂದ ಸುಮ್ಮನೆ ರೆಕಾರ್ಡ್ ಕೊಟ್ಟ, ಅದ ನಾನ್ ಬರ್ದಿಲ್ಲ ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ. ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಡಾಕ್ಟರ್ ಕರ್ಸಿದ್ರಿ. ಆ ಡಾಕ್ಟರ್ ಹಂಗೆ ಹೇಳ್ತಾನೆ, ಯಾರೋ ಬಂದು ಹೇಳಿದ್ರು ನಾನು ಬರ್ಕೊಂಡೆ ಅಂತ. Do you think it is safe to rely upon such evidence to come to the conclusion that he is fraud committed? It's a case of paraplegia. ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಹೇಳಿದಲ್ಲ 2/5/2000 time of 12 AM, the petitioner was walking from Mullikere couple and towards Cable. Column is lawyer ಬರಿ ಇರ್ತಾನೆ. ಹೇಳಿದಾರ ಪ್ಲೇಸ್ ಟೈಮ್ ಹೇಳಿದಾರಲ್ಲ ಶಂಕರ್, ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ 2/5/2007 ಅಂತ ಡೀಟೇಲ್ ಹೇಳಿದ್ದಾರೆ. ಇಲ್ಲ ಮುಗಿಸ್ಬೋಣ, ಇಲ್ಲ ವಾಪಸ್ ಕಳಿಸ್ಬೇಕಾಗ after recording finding that the accident took place. ಇಲ್ಲ ನೀವು ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ತಂದಿರೋದು unreliable. ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟೋದು unreliable. I am satisfied that the evidence is not sufficient to hold that there is fraud committed. ಇಲ್ಲ ನಿಮ್ ಲೂಪ್ ಹೋಲ್ ಸರಿ ಮಾಡಕ್ಕೆ ಇನ್ನೊಂದ್ಸಲ ಚಾನ್ಸ್ ಕೊಡ. If established medical evidence showed that the deceased suffered injury, the doctor has not even taken the signature of that person in the case sheet. I will record a finding that the accident has occurred and this finding. If prove ಮಾಡಿಲ್ಲ ಅಂತ ಇನ್ನೊಂದ್ಸಲ ಪ್ರೂವ್ ಮಾಡೋ ಅವಕಾಶ ಕೊಡೋದು. You took up this contention. You have produced evidence. Finding is recorded. I am sitting in appeal over that finding. If I disagree with the finding, I have to hold to the contrary in the light of the fact that the driver admits the accident. That you establish ಮಾಡಿಲ್ಲ. You should establish collusion. ಅವನು medical evidence, so if he has lost consciousness, ಅವನಲ್ಲ ಆಪರೇಷನ್ ತಗೊಂಡಿದ್ರಲ್ಲ ಸಾಕ್ಬಿಡು. Who was the owner? Owner driver.
First respondent is the driver, the not second respondent is the owner.
This appeal is filed. challenging the dismissal of the claim petition by the claimant. The tribunal, as after analyzing the evidence, has concluded that the claimant was guilty of fraud and he had not actually suffered any accident, and therefore his claim petition was required to be dismissed. The tribunal has come to this conclusion primarily on the basis of the records that it summoned from the Gopal Gowda Shantiveri Memorial Hospital, in which in the case sheet it has been recorded as the claimant had an history of fall from height. The tribunal has taken the view, since it had been recorded at the very earliest point of time that the claimant had suffered a fall from the height, the entire story setup of an accident having occurred due to the auto rickshaw cannot be accepted. In order to substantiate the entry in the case sheet, the doctor who had made the entry was examined by the insurance company as RW2. RW2, during his examination chief itself, has stated as follows. Page 53. A reading of this deposition of Dr. Umesh indicates that the entry in the case sheet was made on the basis of a statement made by the person who brought the claimant to the hospital. The person who made the statement is not disclosed by the doctor, nor is any attempt made by the insurance company to secure the presence of the person who brought the claimant to the hospital. It may also be pertinent to state here that the claimant got himself admitted thereafter to KR Hospital, where he underwent several other procedures. The case sheet maintained by KR Hospital states as follows. Page number 9. As could be seen from this entry, the claimant stated that he had lost consciousness for half an hour, and when he awoke, he found that he could not move his legs. Having regard to the fact that the claimant had lost consciousness for half an hour, and having regard to the fact that the doctor made an entry regarding history of fall on the basis of a statement given by an unknown attender, it would not have been proper for the tribunal to record a finding that the claimant was guilty of fraud. The evidence on record indicates that the claimant had suffered a spinal injury and was hospitalized for 45 days. The medical record also indicates that the claimant could not essentially move his legs. So, having regard to this admitted position, the fact that there was a delay in lodging the complaint by about a month would also become irrelevant. The claim petition was filed against the owner as well as the driver. It's the driver as well as the owner of the auto rickshaw. The driver who filed his objections contended that the accident had occurred due to the rash and negligent act of the claimant himself. So thus, the driver essentially admitted the occurrence of the accident. The owner of the auto rickshaw also reiterated this very contention. Therefore, both the owner as well as the driver admitted the occurrence of the accident. The police, acting on the complaint of the claimant, had investigated the matter and also laid a charge sheet against the driver of the vehicle. These facts established that an accident did occur in which the claimant suffered injuries. The insurer, who also filed objections, did not raise the plea that respondent number 1 and 2 had colluded with each other. The insurance company did not establish that respondents 1 and 2 were colluding with the claimant so as to defraud the insurer. In the absence of any evidence to establish that there was collusion between respondents 1 and 2 with the claimant, the argument that there is collusion cannot be presumed merely because the insurance company so contends. Having regard to the fact, the police have investigated the matter, and having regard to the fact that the driver of the motorcycle of the auto rickshaw and the owner admitted the accident, and the police have also laid a charge sheet against the driver. In my view, the finding of the tribunal that no accident occurred cannot be accepted, and the same is accordingly set aside. It is hereby held that an accident did occur between the auto rickshaw and the claimant has suffered injuries. The tribunal in the impugn order has, however, not assessed the damages, obviously because it was dismissing the claim petition on the ground that there was no accident. In view of the fact that there is no assessment of the injuries and the entitlement to compensation, the matter is remitted to the tribunal to consider and determine the extent of injury suffered and the compensation that the claimant would entitle for the said injury. The award of the tribunal is accordingly set aside and the matter is remanded as stated above. I'll repeat others next week. Yes. Next week, Wednesday, brother.
ಕೊಟ್ಟಪ್ಪ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಯಾವಾಗ ಬರುತ್ತೆ?
ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ.
ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ. ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.